Ready to go. This is calling the case of Sammy Jackson, plaintiff versus Palace Protection, Inc., respondent. Claimant, opening statement, please.
Thank you, Chief Arbitrator. And before I begin, I would like to make the members of the panel aware of several stipulations that we've made with the other counsel. Exhibits G, H, I, M, N, and O are all going to be entered into the record as agreed with opposing counsel. This means that the depositions and signed affidavits, along with the exhibits portraying the law in New Dover, will not be stipulated to being entered into the record. May I proceed with opening statements?
Do the respondents agree with that agreement?
Yes,
Agree.
Chief Arbitrator. That's correct.
EHIMNO. Everything else is not. Okay. With nothing further, claimant, please begin.
Thank you. Imagine dedicating your entire life to teaching children. Each and every year, you diligently saved every penny of your hard-earned money for retirement. Now imagine that upon retirement, you had plans to relocate to Sunshine City, far away from the brutal winters you experienced in northern Wisconsin. You had plans to build a dream home there and finally get some well-deserved relaxation. This is what Sammy Jackson did. This is Sammy's story about hard work and dedication. My name is Joshua Zelen, and I, along with my co-counsel Maggie Revera, represent the claimant Sammy Jackson. This is a case about broken promises and bad faith. Instead of celebrating a long career and living in her dream home,
Hi, baby.
Sammy Jackson was forced to live in an 8-month-long nightmare. As many prudent retirees would agree, managing your personal finances in retirement is a balancing act. One must weigh the value of each expense carefully. In late December of 2018, a sales representative for the respondent named Carrie Chambers pitched several home warranty coverage packages to Ms. Jackson. Ms. Jackson, liking what she heard, ultimately chose the bronze package, which only covered major structural defects. On February 14th of 2019, Sammy Jackson moved into her new home. A mere 2.5 weeks later, on March 3rd of 2019, the shower in her only bathroom began to leak. You will hear from Ms. Jackson that from the time the leak started, she diligently and repeatedly followed up with the builder of her home, Cortex. With Cortex efforts failing to correct the leak, Ms. Jackson contacted the respondent. As respondent's representative, Carrie Chambers, testified in his deposition, he told Ms. Jackson that she would need to provide proof that she first sought redress from Cortex as required by the contract before Palace Protection would step in. This is the first instance of the respondent blurring the terms in order to avoid triggering coverage. This proof requirement before action can be taken is nowhere to be found in the contract. You will hear from Ms. Jackson that she was never told what she had to do in order to fulfill this redress requirement. The respondent instead intentionally avoided informing Ms. Jackson how to provide proof of redress, effectively avoiding their performance under the contract. When Cortex went bankrupt, Ms. Jackson felt confident that the respondent would finally step in. Finally, 4 months into this nightmare, respondent sent a worker to Ms. Jackson's home, who with the naked eye determined there was no structural defect, replaced the caulking at the base of the shower, and called it a day. Respondent relied on this same worker's assessment that no structural defect existed, despite the leak returning a week later. Why at this point did the respondent still assume that the leak was due to poor caulking and not something more serious? Why was a worker not sent again when the leak returned? Why did the respondent cease all contact with Ms. Jackson from that point forward? Members of the panel, as you will see, this is the handiwork of Palace Protection. Their long-term solution simply did not work, and they did not fulfill their obligation. Perhaps they were afraid that the true cause of the leak was something more serious, something that they would have had to provide coverage for, something that we now know was, in fact, a structural defect. Members of the panel, we are here today because the home warranty drafted by the respondent was breached when the respondent denied Ms. Jackson coverage for the defect in her home. We are also here because the respondent acted in bad faith in its dealings with Ms. Jackson, misrepresenting the terms of the contract and unreasonably ceasing communications with their paying customer. In other words, the respondent breached their policy and abandoned their customer. Through evidence and testimony, we will demonstrate 3 reasons to find in our client's favor. First, the respondent materially breached the home warranty contract by denying coverage to Ms. Jackson. Second, the respondent engaged in bad faith using dishonest tactics to avoid its liability under the warranty. And third, Ms. Jackson's comments about the respondent posted on the internet do not constitute defamation. To our first point, a breach of contract exists when there is an existence of a valid contract, the claimant performed or tendered performance, the respondent breached the contract, and that damage has resulted due to that breach. Here, the contract was valid and signed by both parties. Ms. Jackson complied with all of the terms and conditions. The respondent breached the contract when it denied coverage to Ms. Jackson despite this compliance. And as a result, Ms. Jackson was forced to pay a large sum of money that should have been covered under the terms of the contract. And then to our second point, under New Dover law, to prove a bad faith claim, the insured must demonstrate that the insurance company engaged in affirmative misconduct without a good faith defense. And second, that this misconduct must be dishonest, malicious, or oppressive in an attempt to avoid its liability under an insurance policy. Here, the respondent misrepresented key requirements of the contract. When respondent took action, they ignored clear signals that the leak was more serious and chose to ignore the possibility. Respondent deliberately chose to abandon their customer and cease performing their end of the bargain. As you will hear today, the home warranty that Ms. Jackson purchased contains a multitude of provisions, exclusions, and limitations. However, notably, the contract does not exclude reimbursement for repairs made by third-party construction companies. And all of this misconduct by the respondent was done in an effort to avoid its liability under the warranty. And finally, to our third point, Ms. Jackson's posts on social media were honest opinions about her experiences with the respondent. In New Dover, sharing an opinion is not defamatory. Sammy Jackson will testify to her diligent and repeated efforts to get Cortex builders to resolve the situation before contacting the respondent, how the respondent elusively tried to avoid its liability under the warranty, how in the rare moment that they did take action, they chose to take the cheap route instead of the correct route, placing their interest above the well-being of Ms. Jackson. And finally, Ms. Jackson will speak to the respondent's abrupt silence shortly before she received confirmation that the defect was covered by the warranty. You will also hear from Gail Nico, who will testify that the leak was in fact caused by a structural defect, that his findings indicated this defect was covered under the terms defined in the warranty, and that this defect required extensive repairs in order to resolve. We ask that you find respondent liable to Ms. Jackson and award our client $89,000 total in contract damages. This represents the cost to complete the covered repairs under the home warranty, which were $79,000 and a $10,000 cost of an engineer's assessment. Should our client prevail, we respectfully ask this panel to consider awarding treble contract damages pursuant to New Dover Review Insurance Statute 79 and any other remedy this panel deems appropriate. Ms. Jackson has earned her retirement, and it's time we wake her up from the nightmare that it has become. Thank you.
Cross? I'm not sorry, not Cross. Respondent's opening.
Of course. Chief arbitrators and members of the panel, good afternoon. In light of the claimant's opening statement, I want to make some things perfectly clear. Palace Protection is an established business with decades of experience in the home warranty business. Palace Protection creates clear and explicit contracts that outline the parameters of each agreement. It is what they did with Sammy Jackson, and it is what they do with every client. My name is Sean Lewis, and I, along with my co-counsel, Drew White, represent the respondent, Palace Protection. Now, today, you'll hear a lot of back and forth about what happened leading up to the execution of the warranty agreement. But all of that is extraneous information that is beyond the scope of why we are here today. Today, we have to look at the plain meaning of the contract that both Sammy Jackson and Palace Protection signed. Now, I'd like to take just a few moments to address the first claim of breach of contract. Ms. Jackson claims that Palace Protection breached the home warranty contract, but today you'll see that Palace Protection always provides its customers with clear and explicit language that outlines the parameters of each agreement. So let's talk about that language. Today, you'll likely hear that Ms. Jackson only experienced a leaky shower, which is not a structural defect based on the language of the agreement that she signed. Carrie Chambers, a representative for Palace, will tell you that the contract that both Palace and Sammy signed only invokes performance under very specific circumstances, such as when there are problems with the joists or trusses. Here, testimony today is going to demonstrate that Sammy Jackson had a plumbing problem, which is not covered in her warranty agreement. 2 employees of Palace Protection separately assessed the shower and diagnosed a plumbing problem. It was only when Sammy Jackson paid a private contractor that a structural defect was diagnosed. Then, without trying to mitigate, Sammy Jackson came straight to this panel before giving Palace Protection any information, with a bill of over $100,000 with no evidence to support a breach. Additionally, you'll hear that the contract will not cover poor workmanship or damage to the home by Ms. Jackson or her guests. Yet Ms. Jackson repeatedly used chemicals that deteriorated the fresh caulk that Palace installed as a favor to their client. Palace Protection upheld their end of the agreement, but Ms. Jackson simply did not. Next, let's talk about Ms. Jackson's bad faith claim. Now, the claimant just tried to tell you that this case is all about bad faith. So let's talk about that. Under New Dover law, one is entitled to damages for bad faith when 1, there is affirmative misconduct by the insurance company, and 2, the misconduct is dishonest, malicious, or oppressive. You'll likely hear from the claimant that Palace Protection stopped returning Ms. Jackson's phone calls and refused to fix the problem. But let me be clear. Under the terms of the contract, Palace Protection had no obligation to send someone out to look at a plumbing issue, but they did. Palace Protection had no obligation to repair the caulk after it clearly deteriorated from the use of harmful chemicals, but they did. Palace Protection had no obligation to return to the problem to see if the problem was fixed, but they did. In fact, after reviewing the bathroom a few weeks later, Laura Garrison will tell you that the caulk was still in place and the shower was not leaking. Ms. Jackson's problem was fixed. And as a signatory to the contract, Ms. Jackson should have understood that Palace Protection did not assume performance based on doing some mere inexpensive recaulking work. Now, finally, I would like to address Palace Protection's counterclaim against Ms. Jackson. As the old saying goes, Ms. Jackson, you're entitled to your own opinion, but not your own facts. Ms. Jackson defamed Palace Protection when she posted on the internet that we left her with no help and that Palace Protection fails to live up to their promises. But testimony today will support that that is simply not the case. That's flat out dishonest. Palace Protection looked at Ms. Jackson's shower, recaulked it, and performed due diligence 1 week after, but none of which was an obligation of Palace Protection. Ms. Jackson herself will likely testify today to the assistance that was provided directly from Palace Protection. Members of the panel, words have consequences. And because of Ms. Jackson's disregard for the truth, Palace Protection has lost over $150,000 in lost business. Now, the claimant will not be able to prove that Palace Protection breached the warranty agreement and engaged in bad faith business practices, because we did not. But we do expect to prove that Ms. Jackson directly harmed Palace Protection with her dishonest statements. Therefore, we ask that the breach of contract and the bad faith claim be denied, and that Palace Protection be awarded damages for the respondent's counterclaim. We ask this panel to examine the plain meaning of the warranty agreement that Ms. Jackson willingly chose. Thank you.
Would all the witnesses that are going to testify please raise their right hands and be sworn? I assume I can see you. Do you solemnly swear the testimony you're about to give will be the truth?
I do.
Claimant, call your first witness, please.
Thank you, Chief Arbitrator. Our first witness will be Sammy Jackson. Hello, Ms. Jackson. Thank you for being here today. I'm going to ask you a few questions about your experiences involved in this arbitration. Could you please introduce yourself to the panel?
Hi, my name is Sammy Jackson, and I am a new homeowner in Sunshine City, New Dover.
Tell us a bit about yourself.
Sure. I'm 67 years old, born and raised in Wisconsin. I lived there my whole life. I was a fourth grade teacher there for 40 years, and I loved Wisconsin. I love teaching, but I always dreamed of retiring someplace warmer, someplace where I felt a little less alone and isolated, and I found Sunshine City to build that dream home for myself.
Why did you decide on Sunshine City?
I first visited Sunshine City on a sort of spring break trip I took with my very best friend one school year, and I automatically fell in love with the place. It was warm, and the people there were warm and welcoming, and it was affordable. I knew that I wouldn't feel so alone there.
What did you do after you first visited Sunshine City?
The summer after that spring break trip, I went right into researching for my new home. I researched plots of land, and I also researched builders, and I found Cortex builders to build the home.
Now I'd like to talk to you about palace protection. When did you meet Mr. Chambers?
I first met Mr. Chambers on December 27th of 2018. I was actually visiting my construction site. I was really excited to see all the progress so far. And this man approached me and asked if I was going to be the new homeowner.
What was your impression of Mr. Chambers?
I was a bit caught off guard, to be honest. I thought that he was going to be a new neighbor, but that wasn't the case. When I told him I was going to be the new homeowner, he automatically went in on a sales pitch about home warranties and how I should really purchase a home warranty from Palace Protection, his company. And he told me that Palace Protection would be there to support me in any problems that I had with my new home.
Did you decide to purchase a home warranty that day?
Yes, I did.
Could you explain why?
Yeah, I mean, I'm 67 years old. I live alone. Can't really lift many things nowadays, let alone try to repair or build something. And this is a new place for me. I don't know anybody here. And I really thought that Mr. Chambers was telling the truth when he told me Palace Protection would support me.
Ms. Jackson, may I now direct your attention and the attention of the panel to Exhibit I on your screen, also found on page 29 of the case file. Is this the contract you signed?
Yes, it is.
How did Mr. Chambers walk you through the provisions of your contract?
We went through the provisions together. I understood that it was a limited warranty contract, and he seemed to explain it to me fine.
Do you feel that Mr. Chambers fully explained the limitations of your contract?
Well, at the time, I thought he was being honest, but I mean, when I got a limited warranty, I didn't know that with Palace Protection, that really means no warranty.
Now I'd like to talk to you about your experiences in your new home. When did you move in?
I moved in on Valentine's Day, 2019.
How did the move-in go?
The move-in went okay, but shortly thereafter, my one and only shower started leaking.
Can you describe that leaking?
Yeah, it was very weird. So it wasn't coming from the shower head or from the faucet at all. It was coming from the base of the glass where it met the base of the shower. I couldn't really tell where the source of the leak was coming from, but again, it was just really bizarre. And I also just noticed something was off in my bathroom.
How often did the leaking occur?
Every single time I would shower. I was on my hands and knees cleaning up puddles and puddles of water to try to keep my floor dry. It got pretty bad.
What did you do after you noticed the persistent leaking?
I called Cortex Builders right away.
Is there a reason you didn't first call Palace Protection?
Yes, I knew that under my contract, I needed to first seek redress with my original builder, Cortex, before I would get any help from Palace.
Did Cortex fix the problem?
No, they sent over a handyman about 10 days after I called, and he added new caulk around the base of the shower, but that did absolutely nothing to help the leak, and it was back in full force really quickly after he came.
What happened next?
So after that, I actually continued to call Cortex in April, and I got in touch with a project manager there, Jamie Sanchez. She came over right away, and she told me that she also felt something was off in the bathroom, but not only that, my entire shower enclosure had to be replaced.
Was Jamie Sanchez able to fix the problem?
No. After that, I didn't hear from Cortex for all of April, and I called them every single day during the month of April. They didn't answer those calls, and they never called me back.
Now, when was the first time you made Palace Protection aware of your problem?
On March 30th of 2019.
Did Palace Protection step in on March 30th?
No, they did not.
Did you contact Palace Protection again?
Yes, I called Mr. Chambers again on May 1st, 2019, and I told him that the problem I called about all the way back in March was not fixed and that there was something wrong in my home, and I asked for some help.
How did you describe your problem to Mr. Chambers?
I said that there was a defect in my home that was causing a leak in the shower.
When you told Mr. Chambers about this defect, did he send someone over from Palace Protection?
No, he told me that I hadn't done enough to pursue Cortex. But again, this was after I had contacted Cortex every single day during the month of April with absolutely no returned calls.
Did Cortex come back again to fix the problem?
No, they never did. And I actually ran into that project manager I mentioned earlier, Jamie Sanchez, in the grocery store of all places, and she informed me that Cortex had gone bankrupt.
After Cortex filed for bankruptcy, what did you do?
I immediately called Palace Protection. I mean, I felt sorry for Jamie, but I was almost excited because finally Palace Protection would have to step in.
How did Palace Protection respond?
Well, they didn't step in. Mr. Chambers told me that he needed to verify the bankruptcy of Cortex, and that took a while.
How long did it take?
It took over 2 weeks, and during that time I didn't hear anything, so I started calling after 10 days to see what was going on, and all of those calls to Palace Protection went unanswered and unreturned until finally a project manager from Palace Protection, Lori Garrison, just showed up at my door on August 1st.
How did Ms. Garrison assess the problem?
I wouldn't call it assessing the problem. She basically came into my bathroom, looked around, and that was it.
Did she use any tools to assess the damage?
None.
Did Ms. Garrison fix the problem?
No. Miss Garrison had a handyman come over and redo the caulk, just like the handyman from Cortex redid the caulk. So I knew that this wasn't going to work, and it didn't work. It didn't help at all.
What did you do when the shower started leaking again?
I started calling Palace again. I tried and I called and called and called, and those calls went unanswered and unreturned.
When were you finally able to get in touch with Palace Protection?
Mr. Chambers finally answered the phone in the beginning of September, and I asked him to please send over an engineer so that I could have the problem in my home properly assessed.
Why did you specifically ask for an engineer?
I knew that this wasn't just a leak in my shower. There was something that was majorly wrong in my home that was causing the leak. It wasn't the leak causing the bathroom to feel off. It was the other way around, and I needed this problem fixed.
Did Mr. Chambers agree to send an engineer?
No, he actually refused to send an engineer, and then I was not able to get my problem assessed, and Palace Protection didn't even try to assess it. They really avoided sending an engineer so that they couldn't find the real problem.
Did you call Palace Protection again?
Yes, I did. I called and called and called, and all of those calls were unanswered, unreturned. I started sending emails because they weren't picking up the phone. All of those emails were unanswered. And then finally, I got a pretty abrupt email in November from Mr. Chambers.
What did this email say?
It said, "You are not covered. You are on your own."
At this time, did you still believe you were a client of Palace Protection?
Of course. My contract extends 5 years past my move-in date, and I hadn't even been there for a year at that point.
Ms. Jackson, may I now direct your attention and the attention of the panel to Exhibit M on your screen, also found on pages 35 and 36 of the case file. Ms. Jackson, do you recognize these photos?
Yes, these are pictures of my shower.
Who took these photos?
I did.
When were they taken?
On November 1st, 2019. So after Palace Protection did all they could to help with the problem.
What do these photos show us?
They just show the deteriorated state of my bathroom. I mean, this is what Miss Garrison was able to help with. Clearly, the caulking didn't work. Clearly, there was a major problem here.
Speculation.
The objection?
Speculation.
Sorry, I couldn't hear you.
Speculation, Chief Arbiter.
I'm sorry. Repeat it slowly, please. What's-
Objection as to speculation when the witness is testifying as to whether the caulking worked in the home repairs.
Apparently it didn't work, so how is it speculation?
Well, we have Gail Nico here to explain the home repairs that were done and whether what was completed, was actually effective.
Well, I don't know, that's why we're here,
Okay.
okay? You get to cross. Objection as it's stated is overruled.
Thank you, Chief Arbitrator. Well, you can continue, Ms. Jackson. What do these photos show us? Let's finish your thought.
I mean, they show the deteriorated state of my shower. It was a really awful experience. This is the one shower in my home. I was having to clean up puddles and puddles of water after this re-caulking job by Palace Protection. It didn't fix the leak and it didn't fix the major problem that was going on in my home.
What did you do next?
So after they sent that email to me saying that I was on my own, I went out to try to get this problem fixed on my own. I got in contact with a local engineer, Gail Nico, and I asked for him to please come over to properly assess the situation in my home.
When did Mr. Nico come to your home?
He came over that same day on November 10th.
What did Mr. Nico recommend?
Mr. Nico pretty much confirmed all of my worst fears. He said that something was in fact off with my home. He actually said that the floor joists in my home were installed improperly.
Hearsay.
All right, I couldn't hear it. Did you make another objection?
Yes, Chief Arbiter. I was objecting to hearsay as to what Gail Nico stated was the cause of the leak.
That made statement made to prove the truth of the fact and evidence?
Yes, Chief Arbiter. The opposing counsel is offering it to discuss whatever the structural defect is that Mr. Nico alleges. And, they're using Sammy Jackson to get this information in when we have Gail Nico here to testify as to his findings.
Okay. What else? What else?
I would also say improper lay opinion.
Overruled, you get to cross.
Thank you, Chief Arbitrator. You may continue, Ms. Jackson. What did Mr. Nico recommend?
So he told me that the floor joists were installed improperly. And so he recommended that I needed to actually have even floors in my home. In order to do that, I had to remove all of the fixtures in my bathroom so as to properly install level floors. And then I had to put back on all of the appliances and fixtures in my bathroom correctly this time.
How much did this assessment cost you?
$10,000.
Did you contact Palace Protection again after hiring Mr. Nico?
No, of course not.
Why not?
Well, because of my past experience with them over the 8 months that I had to deal with them. And then that email of them telling me that I was on my own to fix this problem, I understood it as they told me. I was on my own. This problem had been going on since I moved in and I needed it fixed. And not only that, I know that I could give written notice of any structural defect under my contract 5 years past my move-in date. And at this point, again, I wasn't even there for over a year.
May I now direct your attention and the attention of the panel to Exhibit N on your screen, also found on page 37 of the case file. Ms. Jackson, do you recognize this document?
Yes, this is the bill for the construction I had to have done in my home.
You mentioned you had to pay $10,000 for the assessment. How much did the repairs cost you?
$79,000.
Ms. Jackson, can you describe how this whole ordeal has affected you?
I can try. I guess the best way to say it is that my dream, my lifelong dream, and the dream that I worked and saved so hard for 40 years has really just been shattered. I'm embarrassed to say that I'm currently out of retirement. I have to tutor local children in the area just to stay afloat. I'm also on the verge of bankruptcy. You know, when I moved here, I was excited and I thought Palace Protection would be there to support me, like Mr. Chambers told me. But I guess he was truthful with one thing. I truly am on my own.
Well, I think I speak for everyone that we're truly so sorry what you've gone through in regards to retirement. Thank you so much for your time and no further questions at this time.
Cross.
Yes, Chief Arbiter. Good afternoon, Ms. Jackson. My name is Drew White. I'd like to ask you some follow-up questions. First, I'd like to discuss your understanding of the warranty agreement. I'd like to direct your attention to what has been previously admitted as Exhibit I. Now, this is the contract between you and Palace Protection, correct?
Yes.
You stated previously that you agreed to the terms in this contract.
Yes.
And as proof of that, on this 4th page, this is your signature?
Yes, it is.
Now, Ms. Jackson, you understood that there were different levels of protection.
Yes, I did.
Because Mr. Chambers discussed these levels with you.
Yes.
And you understood that you selected the bronze limited warranty.
Yes, this was the one that I could afford.
And previously in your prior testimony, you discussed your thoughts on what was covered under the contract. So let's look at what the contract states it covers. Now it says that this coverage is strictly limited to defined structural element failures and does not extend to other deficiencies. I read that correctly?
Yes.
And you stated as well that Mr. Chambers went through these provisions with you.
Yes, I understood the contract I was signing.
And looking to what is defined as a structural element failure is something like a joist deflection of 1 inch and 15 feet.
Yes, that's listed there.
Or a truss deflection of 1 inch and 10 feet.
Yes, that is also listed there.
Or something like a crack in the foundation.
Yes, that says concrete beams cracked. Yeah.
Now to what is not covered under the contract. Now this agreement specifically says that the warranty doesn't cover defined structural element failures caused by things like fire. I read that correctly?
Yes, it says this builder's limited warranty does not cover any deficiencies or defined structural element failures resulting either directly or indirectly from the following causes or occurring in the following situations. A, fire.
And yes, Ms. Jackson, I appreciate you reading it, but I'm just highlighting a few different exclusions that the contract provides as to what is not covered. Another one of these things is moisture.
I believe it would be deficiencies or defined structural element failures resulting from moisture.
Or mildew.
Right, if there was a defect or defined structural element failure that somehow resulted from mildew, that would be covered in my contract. That's correct.
As well as faulty plumbing.
Yes, if there was a defined structural element failure that was caused by faulty plumbing, that would be covered in my contract. That's correct.
Now, you stated that you reached out to Palace Protection first on March 1st, was it?
No, it was March 30th, 2019.
And when you first reached out to Palace Protection, you told them that the issue that you were experiencing in your home was a shower leak.
On March 30th, I said that there was a weird leak in my shower. Yes, I mentioned that something was off.
Now, after you experienced this first leak, you mentioned that a Cortex worker came and added some more caulking around the shower.
Yes, that's true.
But in your own words, you stated that the worker appeared to be rushed.
I don't know that I said that the worker appeared to be rushed, but the caulking ended up not helping or fixing the problem, unfortunately.
This Cortex worker appeared to be in a hurry at the time.
Yes.
You didn't check things carefully.
Did the Cortex worker check things carefully? Is that what you're asking?
Yes, Ms. Jackson, I'm asking you.
No, apparently not.
Now, after this first caulking, only once you became fed up with Cortex, you contacted Palace Protection.
I contacted Palace Protection first on March 30th, and then I also contacted them again on May 1st, 2019, after Cortex didn't answer any of my calls and didn't call me back.
This is because you knew that Cortex, as the builders, were primarily liable for any defect in the home.
I knew that I first had to seek redress according to my contract with Cortex Builders.
Now, about how you dealt with the leak in your shower, you were using Clorox bathroom cleaner to clean the shower area.
No, I used that once to clean the shower area, but after that, I was really just on my hands and knees cleaning up puddles and puddles and puddles, trying to stop my floor from being fully pooled with water.
I appreciate your explanation, Ms. Jackson, but I'm simply asking whether or not you applied this bleach to the base of the shower.
Well, it's Clorox. It's a cleaning product, and I did use Clorox once on my shower, correct?
And you took photos of the shower on November 1st of 2019?
Yes, I did.
I'd like to direct your attention to what has been previously admitted as Exhibit M. Now, these are the two photos that you took of your shower. Oh, I'm having a technical difficulty pulling up the other one. One moment. Now, these are the two photos that you took of your shower, correct, Ms. Jackson?
Yes, correct.
And this second photo, where the floor appears, it doesn't appear that there's any damage to the floor.
To the floor? No, it doesn't appear that there's damage on the floor there.
It doesn't appear that there's any damage to the baseboard.
No.
And you took these photos to show how the shower area had become all moldy.
No, I took them to show just the state of my bathroom and the deterioration of my shower at this point, yeah.
Is it your testimony today that you did not take these photos to show how the area became all moldy?
Objection, relevance. Why does it matter why she took the photos?
The objection. I heard the objection, but what's the objection?
The objection is relevance. He's questioning my witness about why she took these photos, whether it was for mold or to show that the bathroom was deteriorating. Isn't that the same things?
Would that be sort of relevant to the case? Why she took the photos?
I don't believe so, but if this attorney believes that it is, I guess we'll allow it.
Move on. You get to cross. Thank you.
And to be clear, Ms. Jackson, you never provided these photos to Palace Protection.
No, I provided these photos for the arbitration to show the proof of the deterioration of my shower.
But just to be clear, in this second photo, it doesn't appear that there's any deterioration to the floor.
Well, it's under the floor. It's the floor joists that are uneven, so you wouldn't see a deflection in floor joists on the top of my wooden floor there, no.
Now, you brought up that you're allergic to mold, correct?
Objection, outside the scope of direct, mold was never brought up.
Ms. Jackson, you're allergic to mold. And if I may respond, Chief Arbiter, in the competition rules in cross, we are allowed to go outside the scope of direct. We may use anything that the witness included in their prior testimony before the arbitration today.
Okay. Overruled. Move on.
So you agree that you are allergic to mold, Ms. Jackson?
Unfortunately, yes, I'm severely allergic to mold.
But to be clear, you never experienced any health effects relating to your mold allergy.
In my life?
Throughout your entire time in the house, you never experienced any allergic reactions relating to your mold allergy.
No, thank goodness.
So you'd agree?
I'd agree with.
So you'd agree that after moving in, you didn't experience any health effects relating to mold.
No, thank God.
Now let's talk about who you reached out to regarding the leaks. Now, when you contacted Palace Protection, you didn't mention anything of an unlevel floor.
No, I did say on May 1st that there was a defect in my home that was causing a leak in the shower.
But you simply just mentioned the leak in the shower.
No, I said that there was a defect in my home causing a leak in the shower.
But to be clear, you didn't state anything relating to a problem with the foundation.
No, I'm not an engineer. I wouldn't know anything about that.
You didn't reference the floor at all.
No, I did not.
And after Palace informed you that a leak was not covered, you hired a local engineer on November 10th to assess this problem.
Well, it wasn't just after they told me that a leak was not covered. It was after months and months and months of Palace not coming in to even assess the problem that was going on in my home. It was after I specifically asked Palace Protection to send an engineer to properly assess the problem, and they refused to do so, that I had to do my own work and I had to hire a local engineer to finally come over and assess it. It was after they sent me an email saying I was on my own.
Ms. Jackson, we'll get to that in a moment about your interactions with Palace Protection. I'm simply asking you that after Palace had informed you that a leak wasn't covered, you hired a local engineer.
After this entire summer and after the email telling me I was on my own, yes, I proactively hired an engineer.
Now, this engineer, his findings were never provided to Palace Protection.
No.
And per his assessment, you had your bathroom repaired.
Yes.
Now, previously, we went through what was covered in the contract. And in your prior testimony, you also indicated that you're familiar with the contents of this engineer's report. So you are aware that the word joist is not included in Gail Nico's report?
Yes, I'm aware.
And you didn't consult any other engineers to assess this issue in your home?
No, I needed this fixed.
Now let's discuss your social media post about Palace Protection. I'd like to direct your attention to what has been previously admitted as Exhibit H. Now, in both of these posts, you encourage others to beware of Palace Protection, correct?
I state beware of Palace Protection, yes.
And in your Yale post, if you'll just read along silently with me as I state aloud the contents, you state, beware of Palace Protection, Inc. Never hire them. Oh, sorry, this is the other one. Beware of Palace Protection, Inc. I would give them hashtag negative stars if I could. Palace Protection, Inc. fails to live up to their promises. I read that correctly?
Yes, you have read that correctly.
Now, if you read along silent with me as I read aloud your Faces post, in your Faces post, you tell others to never hire them. Correct?
Yes, it says never hire them.
They are a bunch of hashtag deadbeats. Correct?
Yeah. Yes, this is what it says.
You also state that they left me with no help.
Yes, that's what I state.
Now let's discuss your interactions with Palace Protection that you were referring to earlier, specifically the timeline of those interactions. You stated that Palace never returned your calls or emails in your previous testimony, but in fact, Palace Protection spoke with you on May 1st.
I'm sorry, I think you're taking my testimony out of context. I said that after August 7th, throughout August, and then I said that after September, when Mr. Chambers finally answered one of my calls, they never returned any of my calls or called me back.
Ms.
On
Jackson,
May 1st, I called and they did answer me. That's correct.
Ms. Jackson, I understand. I appreciate your explanation, but I was just asking whether or not they called on May 1st, and they spoke with you on the phone on May 1st. That's correct, isn't it?
Sorry, I heard a different question there. Yes, on the phone, they spoke with me on May 1st, 2019 on the phone. That's correct.
And it was at this point you demanded they step in and complete necessary repairs.
I don't think I demanded, but I did explain that I had a problem in my home and I hoped that they would step in. Yes.
And Palace spoke with you again on July 15th.
I called Palace on July 15th, actually, to tell them that Cortex Builders had gone bankrupt.
And after that conversation, Palace ended up sending a handyman to cut out the moldy caulking on August 1st.
Yeah, over 2 weeks later.
And not just a handyman came, but the project manager from Palace Protection came along as well.
A project manager came, yes, and then he had a handyman come to take out the caulking on the shower.
Even though Palace told you that the warranty did not cover maintenance issues.
Correct.
Now, previously, you stated you were excited in a way when Cortex went bankrupt so Palace could step in.
I was hopeful that I would finally get some help.
And Palace replaced the previous caulking that was defective with higher quality caulking.
I don't know how high the quality of caulking was. It didn't work and it was leaking again over a week after that.
And previously you stated that Miss Garrison came to your home and just looked around.
Yes, she looked in the bathroom.
But you'd agree that new higher quality caulking was provided.
Not by Miss Garrison. It was by a handyman from Palace Protection.
And after that first visit, Palace followed up with you again on August 7th.
7 days later, correct.
Coming by to look at your shower.
Yes, to look around again.
And during that August 7th visit, there was no evidence of leaking.
No, I think that I had showered twice in between the August 1st visit and the August 7th visit.
So just to be clear, Palace Protection came out to assess your shower on a total of 2 occasions, correct?
Yes.
And when you called in September after this, all that you discussed was a shower leak, correct?
Incorrect. I asked Mr. Chambers to please send over an engineer to properly assess the problem that was going on in my home.
And at this time, you didn't mention anything regarding the floor or anything other than a shower leak.
No, I was asking for an engineer so that he could tell me if the floors were uneven, so that I could get an expert to finally assess what was going on.
But no mention of the floor at all.
From me? No.
No further questions, Chief Arbiter. I pass this witness.
Call your next witness.
Do we have a short redirect?
Excuse me?
A short redirect, please.
How long?
Ms. Jackson, Sorry,
Count on your time.
thank you. Ms. Jackson, could you explain why you posted those online comments?
Yes, those were my honest and truthful opinions of palace protection, and I believe that I am entitled to my honest and truthful opinions.
And before you hired Mr. Gail Nico, how many times were you calling Palace Protection?
I called and called and called over the course of the summer. They never answered those calls. They never called me back. And then they sent me an email telling me I was on my own.
No further questions.
Now, Claimant, will you call your next witness?
Yes, thank you, Chief Arbitrator. We're going to now call Gail Nico to the stand. Good afternoon, Mr. Nico.
Good afternoon.
Can you please state your full
Can
name?
hear you, please, sir. Keep your voice up so everyone can hear you. You've already been sworn. Go ahead.
Thank you. Mr. Nico, can you please state your full name for the record?
Sure. My name is Gail Nico.
Mr. Nico, what do you do for a living?
I'm a structural engineer with BBK Structural Engineers.
And what is your educational background?
I earned a degree in engineering from the University of Missouri, Columbia.
Are you a licensed engineer?
Yes, I've been a licensed structural engineer for 20 years now.
Mr. Nico, what is a professional engineer license?
A professional engineer license is the industry's highest assurance of quality and competence.
Is this a certification that comes with having graduated from an engineering program?
No, you could have an engineering degree and not necessarily be a licensed professional engineer.
How did you get it then?
Well, it really depends on the board from which you're seeking certification. Usually they require a degree in engineering from an accredited university. And then you'll spend some time interning, gaining hands-on experience in a specialized field. And then you'll sit for a certification exam administered by the board.
I'd like to now speak with you about your assessment process. Throughout your career, have you ever come across structural defects in residential settings?
Yes, the majority of my practice in New Dover is in residential settings.
When you first arrive at a site, what are you looking for?
Well, I'm concerned with that structural integrity. And so I'll look for signs that point to a compromise of that integrity.
What are some signs that tells you a site's structural integrity might be at risk?
Well, if a homeowner is experiencing something like a nagging issue that previous patchwork hasn't been able to solve, that's usually a pretty good sign that there's something deeper at issue. And so I'll make a thorough assessment.
So are tools necessary to make that assessment?
Well, these issues are usually below the floors or between the walls or at the very foundation of the home. And so since these are deeper issues, tools are generally required in order to find these signs that point to these issues.
Once you find an issue or a problem, what do you do?
Once I discover a issue in a home, I'll check my work, make sure that I've used some tools that show that these signs are pointing to an actual structural issue in the person's home. And then I'll take those findings and review them and prepare a report for the client.
Do you ever assume the cause of something based on what a client might say?
I think that clients are able to point you in the right direction, for example, that they're experiencing a nagging issue. But these are serious issues in a home. If a home structural integrity is compromised, the homeowner could potentially be unsafe inside the home. And so I like to do a thorough assessment regardless of whether or not the homeowner has pointed me in a certain direction.
Now, based on your years of experience, can you give us a general sense of what a structural defect is?
Sure. A structural defect is any defect in the load-bearing portions of a home, so much so that the home's structural integrity becomes compromised, and it may be unsafe, unsanitary, or even uninhabitable.
Have you ever discovered a structural defect within a bathroom?
Yes, I've done a lot of residential assessments, so I've done bathrooms, kitchens, living rooms, the whole gambit.
Can you tell us a bit more about what the effects of a structural defect in a bathroom might have on fixtures in the bathroom?
Sure. Well, for example, if a floor is out of level in a bathroom, it's going to cause those fixtures to malfunction. Those fixtures are meant to be built on top of a sturdy, level floor. So if there's an issue with the level of the floor, you're going to have spills and leaks and things of that nature.
Members of the panel, at this time, I'd like to tender this witness as an expert in the field of structural engineering.
Any objection?
Yes, Chief Arbiter, we object under Rule 702. While we are fine with Mr. Nico testifying as to what he did with regard to the repairs, we do not believe that he should be given the latitude that an expert would be giving because neither his expert letter nor deposition indicate whether he's reviewed any documents pertaining to this case, and it's not clear that in his deposition or opinion letter whether his method of assessing the floor or level comports with commonly accepted standards in his field.
Any rule that says that a person has to examine other objects and pieces of evidence before they can testify as an expert?
Would you repeat that? I didn't hear you, Chief Arbiter.
Is there any rule that says that a witness has to examine other reports before they can testify as an expert?
Chief Arbiter, while we understand the rules of evidence are relaxed here in this arbitration, the respondents are asserting that the expert testimony of Mr. Nico comports what has been laid out by the Supreme Court in Daubert, which states that the methodology by which expert is using must conform with what is widely accepted in the field. I can't hear you. One more time.
Don't we have cross-examination for that?
Yes, Chief Arbiter.
Okay. So you can cross. Objection is overruled.
Okay.
Now, Mr. Nico, are structural defects of the type you were just speaking of fixable?
Yes, they are.
What would a long-term solution look like for a structural defect of that sort?
Well, in the example I just gave of a issue with a bathroom floor, you would need to remove those fixtures and then to re-level the floor.
Now, that sounds expensive. Is that correct?
It can be expensive. It depends on the fix and what the issue is in the home. It really depends on what the assessment comes out to be.
Now, are there other more cost-effective solutions that exist?
No. There are surely other options that work as patchwork, but there aren't other solutions. You can think of this in the same way that when you have a toothache, you take some painkillers and the toothache goes away. But over time, that toothache festers and festers, and suddenly you have a cavity, and eventually you have to get a root canal. And so the issues become a lot worse, even though you did some patchwork and you took some painkillers to get rid of that pain. Same goes for repairing a structural defect. You can put some patchwork, or you can solve the issue today and save money in the long run.
Why might someone choose to avoid those other options?
Well, it really depends on the client's financial situation. They may choose to push off a more serious repair for a later date because of that.
Okay, Mr. Nico, now I would like to shift gears now and talk about the assessment of Sammy Jackson's bathroom floor. When did you assess Sammy Jackson's bathroom?
I went to Miss Jackson's home on November 10th after she called me earlier that day.
Can you describe why you assessed her bathroom?
I was called to check in on a leak that she was experiencing that previous solution or option of patchwork, previous work that was done was unable to solve.
Now, have you had the chance to familiarize yourself with all the exhibits in your preparation for today's hearing?
Yes, I have.
May I now direct your attention, the attention of the arbitrators, to Exhibit M on the screen, also featured on page 35 and 36 of the case file.
Yes.
Do you recognize these pictures?
Yes, these are pictures of Miss Jackson's shower base.
Now, as the exhibit indicates, these pictures were taken on November 1st. Was the condition of the bathroom in Exhibit M the same as when you assessed it?
I came 9 days later, but it was substantially the same, yes.
Would you please tell us the methods that you used to assess this bathroom?
Sure. Well, I was called over to assess a leak in Miss Jackson's bathroom. And so knowing that she was having issues with her shower, I went there first to look around. And so I ran the water for quite some time, and I found that there was in fact a leak. The reason I ran the water for some time was to discover whether or not the water might be pooling in certain areas or whether it was draining efficiently and effectively and the way that a normal shower works. I found that there was in fact a leak at where the glass enclosure of the shower and the base met. But after some time, I found that there was water actually escaping from the base of the shower itself. That's where the base and the shower floor meet.
So you found that there was a leak. What was your ultimate conclusion? What was your findings?
Well, after discovering the leak and in a spot where you probably wouldn't expect it to be, I decided to use a high grade level, and I determined that the shower floor was actually deflected, that it was out of level. The right side was higher than the left by 3/4 of an inch.
Now, Mr. Nico, I want to turn your attention to Exhibit I on the screen. And specifically, we're going to look at the highlighted portion at the bottom of page 30. Are you familiar with this?
Yes, I became aware of these definitions in my preparation for this arbitration.
Can you read the definitions highlighted in this exhibit?
Yes. Definitions. Defined structural element failure means that one or more of the structural elements identified below contains a flaw of such a magnitude that the warranty tolerance is exceeded. The only structural elements we cover and their respective tolerances are as follows. Defined structural element warranty tolerances. B, floor systems. 2, joist deflection of 1 inch and 15 feet.
So in consideration of the terms of the contract you just read and the assessment that you conducted in Ms. Jackson's home, what can you conclude?
Well, under the terms of this contract, which lay out a tolerance that would need to be exceeded, Ms. Jackson's home and her out-of-level floor exceeded these tolerances. These definitions call for a deflection of 1 inch and 15 feet, which designates the slope of that deflection. Ms. Jackson had a 3/4 inch difference from the right to left of her standard shower, and so it clearly exceeds the tolerances.
For those of us who aren't as well versed in structural engineering, can you explain the 3/4 of an inch part over 15 feet and how that would relate to, in this case, in this sized shower?
Sure. Ms. Jackson had your standard shower, and there was a deflection of 3/4 of an inch from the right to the left side. This contract allows for tolerances of 1 inch and 15 feet. Now, if we took Ms. Jackson's issue and expanded it over 15 feet, we'd find that there was a difference of, at the least, 2 inches and a quarter of this nature. It's really just designating slope here. And so it would have fallen under the contract and exceeded this tolerance.
Would you classify this type of defect as serious?
Yes, this is a serious issue. It can lead to further issues down the road. Homes are built to settle over time. And when there's an issue with the very structure of a home, that will interfere with its natural settling. And you could have further issues down the line and other structural element failures.
How far back would this structural defect have been detectable?
It was my professional opinion that this was the result of poor workmanship on behalf of the original contractor. And so this type of defect would have been visible and detectable at the time the home was built.
Now, in your preparation for this proceeding, were you aware that other assessments were made prior to your assessment that essentially found the opposite?
Ms. Jackson told me that she had other work done that had failed, yeah.
Now, the people who performed those assessments came to different conclusions. Why could that be?
Well, I'm a structural engineer, a licensed professional structural engineer, and I can't speak to the experience or the qualifications of the other people who did their assessments, but I know that in the time of my being an engineer, over 40 years as a licensed structural engineer and having graduated with an engineering degree, I've learned to look for certain signs that point me in the direction of being able to make the assessment which I made at Ms. Jackson's home. It's possible that the people who made the assessments before me would not have known to look for those signs during the course of their assessment.
What was the course of action that you recommended to Ms. Jackson?
I recommended to Ms. Jackson that we get to the root of the issue now. I told her that the ideal situation would be to remove the fixtures from the bathroom and to re-level the floor.
Were there any other solutions that would have essentially achieved the same result of fixing the leak?
Again, there wouldn't have been other solutions. We could have done patchwork, but this would have had the effect of putting a Band-Aid on a broken bone. It would have held it together for a little while and then suddenly leak again, same issue.
Thank you, Mr. Nico. No further questions at this time.
Yes, Chief Arbiter. May I begin?
Yep.
Hi, Mr. Nico.
Hello.
Let's talk about your visit to Ms. Jackson's home and your ultimate investigation.
Sure.
Now, you saw the site in person. Do I have that right?
Yes.
On November 10th?
Yes.
And you used a level to measure the evenness of the floor.
Yes. Over the course of my assessment, I used a high-grade professional level in order to determine the conclusion that I came to, that there was a difference of 3/4 of an inch from the right to the left side of the shower.
Thank you. And we'll get to all that. No need to rush. And I've got plenty of questions so you can address it. But with regard to your assessment, you charged $10,000 for that assessment.
Yes, the rate of my assessment was $10,000.
And after that, you prepared a written opinion.
Yes.
And that written opinion detailed your findings.
Yes, it was a record of my assessment.
Okay. And that included information about a structural defect.
Yes, I detailed that there were out-of-level floors in Miss Jackson's bathroom. As I've discussed earlier, about the 3/4 of an inch difference from the right to the left side and a pitch of 7/8 of an inch from the back wall.
Thank you, Mr. Nico. And so the answer to my question is yes.
Yes.
Now, on direct examination, you said that the only solution was to Miss Jackson's shower was the structural defect in the floor, right?
The only solution was to repair that structural defect. Yes.
And you were only called about a shower. Do I have that right?
I was called to make an assessment of Miss Jackson's home, which was resulting in a leak in her shower.
And with regard to that shower, you also examined some clips, right?
Yeah. Yes. I saw that the shower had been improperly installed on this out-of-level floor, which caused the clips, which normally attach the glass enclosure to the walls, to not be there.
Thank you. Again, the answer to my question is yes.
Yes.
And with regards to those partially installed clips, as you said, they were detached from the studs. Therefore, the shower was not properly installed. Do I have that right?
Yes, the shower was improperly installed.
And those clips are needed for proper installation.
Yes.
Yet on direct examination, you said the only solution to Miss Jackson's shower was a floor?
No, I said that there were surely other options to fix Miss Jackson's shower and to fix the leak that she was experiencing. However, the only solution was to fix the floor. The shower was installed improperly because it was installed on top of an out-of-level floor. And that's why you had the clips missing and you had the different deflections going on. And that was the cause of Miss Jackson's leak.
Mr. Nico, again, I thank you for the extra information that you included, but most of my questions can be answered with a simple yes or no. Now, that shower was just simple poor workmanship, right?
It was after poor workmanship on behalf of the original contractor with the floor. So yeah.
The shower was improperly installed, and yet you recommended that Sammy replace the entire bathroom.
Yes, because the underlying issue was the situation with her floor.
The shower.
I'm sorry, the shower
You
what?
recommended that the shower need to be replaced?
Yes, the shower would have needed to be replaced because it was
Vanity.
improperly installed. The vanity was removed from the actual bathroom along with the toilet, but those were reinstalled after the floors were re-leveled.
Again, Mr. Nico, the answer to my question is yes, right?
No, it required a clarification because you asked the question and it was no.
The shower was removed.
The shower was removed.
And the vanity and the toilet were also removed.
They were also removed.
So yes. But even though you were only called to assess one thing.
Yes, but the product of my assessment was that there was an out-of-level floor in Miss Jackson's bathroom. These fixtures are installed on top of that out-of-level floor, which necessarily requires you to remove those fixtures in order to then fix the floor.
Thank you, Mr. Nico.
Mhm.
Now, you on direct examination, you also included a lot of calculations about, you came to a lot of conclusions about the width of the shower and the joist deflections and whatnot, but yet nowhere in your report do you even mention anything about truss or joist.
No, I made a record of my report with 3/4 of an inch, everything else that you've heard already.
And nowhere in that same report did you mention anything about a crack.
There was no crack.
And nowhere in the report did you even include any information that comported with the calculations that you just said on direct examination.
I reported in my report the calculations that I made of 3/4 of an inch in her shower, 7/8, all those things.
That wasn't my question, Mr. Nico. I'm specifically asking that nowhere in your report did you mention anything about truss or joist.
You asked about my calculations, and I answered that question regarding truss and joist. Those were not mentioned in the report. I said about the out-of-level floor.
And yet, Sammy Jackson has paid $79,000 for those renovations.
Yes.
Thank you, Chief Arbiter. I pass this witness.
All right. Are you all ready to keep going?
Yes,
don't-
thank you, Chief Arbitrator. This rests the the claimant's case in chief.
Plaintiff rests. Okay, claimant is rested. The respondent,
Yes,
ready to
Chief Arbiter.
proceed?
Yes, Chief Arbiter. The respondents would like to call on Mr. Kerry Chambers.
When you're ready, go ahead.
Hi, Kerry. May you introduce yourself to the panel, please?
Thing. My name is Kerry Chambers. I am a sales representative with PALS Protection. I've been with PALS for 15 years, and I'm also a corporate officer for them.
Okay, Kerry, let's talk about how we got here today. How did you first meet Sammy?
Well, I first met Sammy while I was visiting the 50 and over development in Sunshine City. You know, Sammy was visiting his soon-to-be home, and I was conducting a business visit in the sales office at that development.
Why were you in the sales office?
I usually visit the sales office in new developments. You know, I talk with builders and other representatives about the various warranty plans that we offer here at PALS Protection. And, you know, it's just good for building relationships with developers themselves.
Now, Kerry, is that routine in your business?
I would call it a routine business practice for PALS Protection at this point, yes. You know, we just aim to make sure that clients have the most accurate information regarding our products, and there's really no better way than being on the ground there.
Now, I want to talk to you about your relationship with Sammy. Can you tell us a little bit about how that developed?
Sure. So as we were both in the development, at the 50 and over development in Sunshine City, Sammy was visiting his soon-to-be new home. I was doing my routine business practice. So I approached Sammy and provided him with a brochure about our different warranties. You know, we offered different warranties. And in addition to giving that brochure, I wanted to talk through it with Sammy, and just in case any questions arise.
Now, why didn't you just give Sammy the brochure and leave her to call and place the warranty herself, set it up herself?
Well, you know, I've been 15 years as a sales representative. I would call that a rookie mistake. You just want to be there in case clients have any questions. The brochure's not going to explain everything. And even if it does, customers are always going to have questions. So it's a customer service. And, you know, I just wanted to be absolutely clear that Sammy had all the facts regarding our products before making a decision.
You said you wanted to ensure Sammy had all of the facts. What do you mean by that?
Well, I very clearly talked through all the three packages, which include the gold, the silver, and the bronze. So that's what I was referring to as all the facts.
Okay, let's have you explain those packages to the panel from the top down. First, can you tell me about the gold package?
Sure thing. So the gold package is our most comprehensive package. It covers all defects and systems. It even includes appliances that are installed during new construction. And the premium, which is the cost for this package, is $750 per year, which is also our most expensive package.
Does that vary much from the silver package?
Yeah, slightly. You know, the silver package is slightly less expensive, and it covers most type of defects except those separately installed appliances that would go to the gold package.
And what about the bronze package?
So that package, the bronze package, is our cheapest package and also the most restrictive. It doesn't include plumbing or appliance problems. It actually only applies when the builder isn't available, and it only covers structural defects that are delineated per the contract.
So which plan did Sammy ultimately choose?
Well, Sammy ultimately went with the bronze package.
And are there any exclusions in that bronze package?
Yes, the bronze package actually has the most exclusions out of all of our plans. It excludes various things, but most commonly it excludes plumbing issues, any damage that's caused by the homeowners or their guests, and you know, any appliance problems.
And did you explain those exclusions to Sammy?
Well, yes, like I do with all of our clients. You know, for one, Sammy signed the contract, and you know, I explain all of this to Sammy very clearly, again, as I do with all of my clients.
Did you discuss anything else with Sammy while signing the agreement?
No, you know, but throughout this arbitration thing, I've learned about this mold allergy, but, you know, I really don't recall that at the time of when I was trying to make the sales pitch for our very helpful warranties.
Let's talk about what happened after Miss Jackson moved in. Did Sammy contact you at any point after she settled into her home?
Yes, Sammy began calling on numerous occasions. These began in May 2019, and there were about a leaky shower.
And what, if anything, did you tell her in response to that leaky shower?
Well, like all of our bronze customers. I told her that she needed to contact the home builder first because that's what the agreement calls for.
And did you ever hear back from Sammy after that?
Yes, throughout the summer. And at some point, Sammy finally told me that perhaps provided me with some information that perhaps Cortex would be bankrupt.
What happened after that discussion?
So I went ahead and verified whether Cortex was actually bankrupt. And, per Sammy's agreement, we just went ahead and sent Lori Garrison, which is one of our project managers. This happened, I believe, on August 1st.
Did you check Sammy's contract prior to that?
Well, beyond the sales pitch, it was the bronze package. So I've been working with past protection for 15 years, so I was pretty clear on what was excluded or not. But, as a courtesy, we wanted to send Lori Garrison to just see what was going on, because again, that agreement covers only structural defects that are delineated very clearly in that contract.
Now, you mentioned Lori. Why did you send her out?
Well, that's one of our best project managers. And besides that, we just wanted to provide good customer service, So we went ahead and sent Lori to check out that leaking shower that Sammy had been calling about.
And based on that visit, did Lori recommend anything?
I'm sorry, repeat that again?
I said, based on that visit, did Lori recommend anything?
Yeah, well, it is my understanding that the shower was caulked, again, because the caulk that was there was of inferior quality. And then about 6 days later, I believe August 7th, Palace again went ahead and checked, visited the site, and there was no leak. Everything was good. The caulk had worked.
So after Lori Garrison had someone recaulk Sammy's shower, did you hear from Sammy again after that point?
I did. Sammy kept on calling, and unfortunately, at some point, I had to stop accepting Sammy's calls because there was nothing else we could do. If we were to take, all sorts of claims at their face value, we would have lots of bogus claims at past protection. And furthermore, Lori Garrison did the caulking job, and then we revisited the site, and there was no leaking, so it worked.
Now, Kara, let's talk about the state of Palace's business today. How, if at all, has anything changed?
Well, business has decreased significantly because of Sammy's post on the internet. We call us deadbeats, and that we left them with no help. My son saw that. I found it really disturbing to an extent.
Is that true?
No. Everything that was said is a flat out lie. We didn't leave him with no help. I was just explaining that we sent Lori Garrison and his shower was recaulked.
And to your knowledge, did anyone other than your son see these posts?
Well, it was my understanding that Knowles family was going to enter into a contract, and they backed out because of these posts.
And what effect did that have on your business?
Well, it cost us money. We made a projection as to the revenue that we had made during the same time this year. We made a projection as to the money we had made last year compared to this year, and it was over $150,000.
And is that why you're seeking damages in this defamation claim?
Yes. I truly believe otherwise Palace Protection would have left us alone, but this is our business. This is my job. This is Lori's job. And it hasn't been the same since those posts. We lost business, and I'm a bit concerned if we're going to be able to keep on going on with these type of losses.
Thank you, Mr. Chambers. Chief Arbiter, I pass this witness. Chief Arbiter, I pass the witness. I concluded my question.
I said cross. Is anybody going cross?
I am Chief Arbitrator. I think we couldn't hear you. Apologize. Hello, Mr.
Whoa. Can everybody understand that?
Sorry?
If everybody can understand her testimony? I can barely understand what she's saying.
Me?
Say testing, please.
Testing.
Margaret?
Yes.
Yeah,
Hello?
say testing.
Testing.
Is everybody else okay? I just got a message that says my internet connection is unstable. Can everybody else hear her all right? Thank you for the thumbs up. Okay, go ahead.
Okay, thank you.
I hear you. Go ahead. I'm sorry.
Hello, Mr. Chambers. My name is Maggie
Hi.
Revera, and I'm going to ask you a few questions today about your experience in the industry generally, and in this case specifically.
Good.
You worked for Palace Protection for
I
15
couldn't understand.
Sorry?
I believe his connection's breaking. He's kind of just frozen.
Okay, can we pause time while we fix this? Mr. Chambers, you worked for Palace Protection for 15 years,
Go
correct?
ahead.
Yes, that's correct.
You stated that you explain the contracts to potential clients frequently. Is that correct?
Yes, with the brochure.
So you have in-depth knowledge of what's stated within the contracts that you provide. Is that correct?
Yeah, I would say so. Although I'm no lawyer.
You testified earlier that clients have to exhaust all options with their builder before seeking redress with Palace Protection. Is that correct?
That's right, as delineated in the contract, the bronze warranty here.
May I now direct your attention and the attention of the panel to Exhibit I on your screen, also found on page 29 of the case file. I would like to note that the highlighting has been added to ease this line of questioning. Could you read the highlighted portion for us, please?
Sure thing. This limited warranty provides coverage in the event that builder fails to make necessary repairs, and home buyer must first seek redress from builder before seeking redress from warrantor.
Mr. Chambers, isn't it true that nowhere in this provision does the contract use the phrase exhaust all options?
No, there is no that explicitly said here, but that's the language that we have there.
But that's not language that's listed in the contract. Is that true?
As to exhaust, no, but what I just read, yes.
What you just read does not state the phrase exhaust all options, correct?
That's right.
You also previously testified that you repeatedly told Ms. Jackson that she needed to provide proof that she sought redress. Is that correct?
I did, yes, in our phone calls.
But isn't it true in that provision that you just read, the contract does never state that proof is required?
No, but if we were like, we needed some sort of point us something in the direction that the builder couldn't come in and do it, because again, that's what the contract calls for, the builder first, then us.
Right, but Mr. Chambers, the contract doesn't call for proof explicitly, does it?
Not explicitly.
May I now direct your attention and the attention of the panel to Exhibit I on your screen, also found on page 30 of the case file. Once again, I want to note that the highlighting has been added to ease this line of questioning. Could you read this highlighted portion for us, please?
Sure thing. Coverage expires 5 years after the warranty date. To be eligible for coverage, we must receive written notice of the defined structural element failure within 30 days, parentheses 30 days after the expiration date of the coverage.
Ms. Jackson's coverage was to extend for 5 years, correct?
Yes.
Isn't it true that nowhere in this provision does it state that written notice must be sent prior to repairs being made?
It doesn't state that there, no.
You testified previously that the bronze package includes a list of extensive exclusions. Is that correct?
Yes, correct.
Isn't it true that nowhere on that list does Palace Protection exclude reimbursement for repairs done by another company?
Would you mind putting that up for me, please?
Sure. One moment, please.
Of course.
It should be on your screen now.
Well, this is the definitions. Are we talking about the exclusions or the definitions?
The exclusion, sorry, one moment. We just have to, I have to find that. It wasn't in our,
There it is.
on my screen. One moment.
Thank you. Okay, but maybe we should just stay on the phone in case they drop out again, which I just did. So I can't make any.
I will move on.
Yeah.
Mr. Chambers, Miss Garrison visited Miss Jackson's home on August 1st, correct?
That's right.
Is it true that Miss Jackson called Palace Protection again after the recalking did not solve her problem?
Right. She did call again in, I believe, September to tell us about the leaky shower, but again, that's not covered under the bronze warranty. Plumbing is covered by the silver.
You previously testified that you just stopped answering Miss Jackson's calls. Isn't that correct?
Unfortunately, I had to. I mean, there was nothing else that we could do. We just had a leaky shower on our hands, and that's not covered under the bronze warranty.
So, but it's true that you stopped answering the phone calls. Is that true?
As I said, yes.
So it's true that you don't know what Miss Jackson was repeatedly calling about because you never answered.
Well, it was the leaky shower because at some point we had to notify her that, it wasn't covered.
But Mr. Chambers, it's true that you don't know what she was calling about because you never answered the phone calls.
Well, from what I got today, it was about a leaky shower, but no, not at that time.
On direct, you testified that Palace Protection lost $150,000 as a result of Miss Jackson's social media posts. Is that true?
That is true.
But you did not provide any evidence to corroborate that figure. Is that correct?
Well, I did when I was testifying.
But you did not provide a copy of an analysis of the profit loss, a financial statement, nor did you provide a tax return to prove this statement. Is that correct?
That's true. That's accurate.
Isn't it true that the limited warranty has a liability limit in the amount of $185,000?
That's right.
Isn't it true that Miss Jackson's repairs cost $79,000?
Yeah, that's true.
So it's true that Miss Jackson's repairs cost a lot less than half the limit of the bronze package.
That's true, although those were, things that were outside her coverage. That limitation is only as to what is covered under the contract, not just any number that, any repairs may cost. It has to be what is in the contract.
Mr. Chambers, you testified previously that, again, you stopped answering Miss Jackson's phone calls. Is that correct?
Again, yes.
And you never sent another worker to assess if the problem was in fact more serious after the recaulking did not work, correct?
Well, the recaulking worked upon visit on August 7th. And, from there on, we just trusted our project manager, Lori Garrison, who is in charge of that, who did make that assessment. So, yes.
And August 7th was 7 days after the caulking was replaced, correct?
That's right.
But you never answered Miss Jackson's calls after that point, correct?
No, until we made contact with her on November 1st, telling her that this wouldn't be covered.
So you never sent anyone else to Miss Jackson's home after August 7th, is that correct?
That's true, because we believe at that time that we had the issue, which we still believe we do. Again, Lori Garrison was sent to assess.
You wouldn't know this because you stopped answering her phone calls, is that correct?
Can you say that again?
You wouldn't necessarily know because you stopped answering Miss Jackson's phone calls as you testified previously.
I did testify that, but what I got from today again was that those calls were about a leaky shower.
We're not talking about what you got today. At the time, you stopped answering Miss Jackson's phone calls without knowing what she was calling about, correct?
Again, yes.
Thank you. No further questions.
Call your next witness, please.
Chief Arbiter, may I briefly redirect?
Excuse me?
May I briefly redirect?
Yes,
Thank you.
sure.
Now, Mr. Chambers, who signed the contract?
Sammy Jackson and myself as a representative of Palace Protection. So by extension, Palace Protection and Sammy Jackson.
Now, why did you send Lori Garrison out?
Well, we just wanted to, check out what was going on. Lori made an assessment, made the call that this was a maintenance problem, recaulked it, and that's, pretty much customer service to answer your question.
And based on that, why didn't you send someone else out again after Lori's recommended changes?
Well, because Lori revisited the site and everything was good. And I mean, Lori is one of our project managers. They made an assessment, and I'm not going to fight Lori on his assessments. I'm sorry, on her assessments. Again, it was just, customer service, and upon revisit, the caulk worked.
And does the warranty agreement mention anything about who is able to perform repairs to a home?
Us, yes, Palace Protection.
And does the warranty agreement mention anything of mandating that Palace Protection revisit a property?
No, it does not. There is no language in it.
And lastly, are you a lawyer?
No. I thought about law school, but I decided not to.
Chief Arbiter, may this witness be excused?
Yes, sir.
Thank you, Mr. Chambers.
Call your next witness. Please.
Chief Arbiter, at this time, the respondent calls witness Lori Garrison to the stand.
Lori Garrison has already been sworn. So Please keep your voice up so everyone can hear you.
Yes, Chief Arbiter. Now, Ms. Garrison, I know we're familiar with one another, but could you please state your full name for the record?
Yes, my name is Lori Garrison.
Ms. Garrison, what is your occupation?
Currently, I serve as a project manager with Palace Protection.
What brings you here today?
Well, I'm here today to testify in my capacity as to completing a home inspection on Sammy Jackson's home and to offer my professional opinions.
In your job as a project manager, how long have you worked at Palace Protection?
Almost a decade now, 9 or 10 years.
What experience have you obtained while working for Palace?
Well, I first worked as an apprentice where I spent a few years learning the trade and developing my craft. Because of my diligence and I love working with my hands, I quickly advanced within the company. Throughout the years, I've become more and more knowledgeable about our home warranties and construction.
And what is the nature of your work entail?
Visiting houses to inspect any issues. I'm great with my hands and I can fix just about anything.
Do you belong to any associations in your field?
Yes, I am active with the NACT, and that's the National Association of Construction Trades.
Could you tell us a little bit about the NACT?
Yeah, the NACT offers monthly seminars on various topics to keep people like me up to date on issues within the construction industry.
Ms. Garrison, how did you use your experience and knowledge to come to the conclusions that you made when inspecting Sammy Jackson's home?
Well, I'm familiar with Palace Protection's duties under our general home warranties, and I was able to come to a conclusion firsthand when I visited Sammy Jackson's home as to an explanation to the leaking problems that she was experiencing.
At this time, Chief Arbiter, I tender Lori Garrison as an expert in home repairs.
Any objection?
We do not have an objection for her as an expert as long as it stays within the confines of home repairs only. We would like to reserve the right to challenge this witness's expertise on specialized knowledge concerning structural engineering, which we will do on cross. Thank you.
What are you going to do? If you don't like it on cross, you're going to object to all the testimony that's in the record?
I'm sorry, what was that?
You accept her or reject her, because if you accept her at this point with a reservation, after all the testimony gets in and then you don't like it, you can say you're going to question it.
Well,
So
we
make a
would
decision.
object. We would object because this witness has shown no level of experience in engineering or anything related to whether or not a structural defect could exist in his home. Her knowledge is very, very limited in that respect, and the opposing counsel has not demonstrated or laid the foundation that this expert or this supposed expert would be able to provide any specialized knowledge whatsoever.
May I respond, Chief Arbiter?
Right, please.
I'm not sure if opposing counsel recognized that I offered Lori Garrison as an expert in home repairs and not as an engineer. We never claimed that Lori Garrison was an engineer, but she does satisfy 702 in that she has the requisite experience in her field. She has education. We saw that she takes courses and training with the NACT. Moreover, Gail Nico was allowed to offer his expert opinion without, bringing up any of his underlying methodologies. And what's good for the goose is good for the gander here. I'm simply asking that opposing counsel be allowed to take up any qualms that he may have with Ms. Garrison on cross.
First of all, Ms. Garrison is going to be admitted or rejected on her, not anything else to do with the gentleman who was testifying before. And I've heard enough that she can testify to what he said she's going to testify to. And if she gets beyond it, there'll be objections. Plus there's cross-examination. So the objection to bar her testimony is denied. Continue, please.
Yes, Chief Arbiter. Now, Ms. Garrison, why did you begin working for Palace Protection?
Well, I specifically chose to begin my career with Palace Protection I learned about Palace Protection's loyalty to their customers and their extensive training program from my mentor shop teacher, actually. I wanted great training so I could advance in the field with the support of a great company like Palace Protection.
Can you discuss how Palace Protection operates in the field of offering home warranties?
Yeah, they're one of the only home warranty companies that does their own warranty repair work. That aspect of the job impressed me because so many other companies hire out and don't take care to ensure quality work.
Well, you mentioned that they complete their own work. Would it be customary then for Palace to reimburse its clients for having outside contractors come in and do work?
I don't think so. You know, that's why we take care to ensure that quality work, to make sure it's good, and that's why we don't hire out.
Now, what is Palace Protection relationship like with its workers?
Well, we're careful to hire folks and train them and keep them happy so that there's continuity in the work that we provide. That's why I've stayed on board for so many years.
Overall, how do you feel about the company?
I love it. I believe in our company's goal, our message, and I'm really proud to work for Palace Protection.
Now let's talk about Sammy Jackson's home and your inspection. What could you tell us about Sammy Jackson's warranty agreement?
Well, the warranty agreement that Sammy Jackson purchased was our most affordable, and it provides the lowest level of protection. It was our bronze level package, as opposed to our more expensive options like the silver and the gold package.
Could you share with the panel a little bit about the bronze level warranty?
Yes, bronze level warranties only cover problems like structural defects. It specifically does not cover plumbing issues.
Now, Ms. Garrison, did you ever go to Sammy Jackson's home?
Yes, I went twice.
When was the first time?
August 1st, 2019.
And why did you decide to go out there?
To inspect for a leak. I only knew that there was a leak and I was there to fix it. And this was provided as a courtesy because Ms. Jackson's warranty does not cover plumbing issues as it is that bronze warranty.
What did you do when you arrived at her home?
Well, I inspected the shower and I saw evidence of leaking from the bottom of the shower enclosure.
What were your thoughts on this leak?
Well, the issue was a pretty simple one. Since it was a leak, I immediately knew what to do, given my years of experience. The caulk that was used and existing was of bad quality and it needed replacing. New caulking would fix the issue.
Did you provide new caulk?
Yes, I directed one of our workers to cut out that inferior caulk at the base of the shower and replace it with a new caulk of higher quality.
Did you have any other objectives on your visit?
No, when we're informed of a leak, we address that specific problem. That's the only issue that I was made aware of, and I've experienced plenty of home repairs.
Now, after this August 1st visit, did you ever return to Sammy Jackson's home?
Yes, I returned once again as a courtesy on August 7th, 2019 to check on the shower.
Did you see any leaking at that time?
No, the problem was fixed. Both the worker and I didn't see any leaking or anything indicating a problem.
Now, given your experience and training, what did you conclude that the issue was?
Poor caulking or bad maintenance caused the issue. That was it. New caulking fixed the issue.
I pass this witness. Chief Arbiter.
Cross.
Thank you, Chief Arbitrator. Hello, Ms. Garrison. My name is Joshua Zelen, and I would like to ask you a few questions about your experiences and about your assessment of Ms. Jackson's bathroom, too. You started working with Palace Protection right after high school, correct?
Yes, yeah, I chose to start work with them.
So you never went to a formal trade school, is that also correct?
Yeah, no, I didn't. That wasn't my path.
And your training in construction was solely by Palace Protection, is that correct?
Yes, they have a training program, and I get some knowledge from the NACT and their seminars.
So you have no formal training as a structural engineer, is that correct?
No, I'm not an engineer.
So it's fair to say that you don't have you're not a licensed structural engineer.
No, I've worked with Palace Protection for 10 years.
Okay, so now let's turn towards your assessment of Miss Jackson's bathroom. When you went to Miss Jackson's house, you did so in order to assess the leak, correct?
Yes, I went to assess the leak.
And following that assessment, you concluded that there was no structural defect present. Isn't that true?
Yes, when I returned, both the worker and I checked out the shower. We didn't see any evidence of leaking or anything indicating a structural defect.
So prior to your assessment, you knew that Ms. Jackson had the bronze warranty, correct?
Yes,
And you were aware that the bronze warranty only covers major structural defects and excludes plumbing, correct?
right. Yeah, that's why we went as a courtesy.
Is it true that you didn't use any tools during your assessment?
Yeah, tools weren't necessary. This was a simple issue, and I inspected and saw that leak, and then we just recaulked it.
Isn't it also true that you didn't take any measurements during your assessment?
Yes, I didn't take any measurements.
So it's true that you concluded there was no structural defect without using any tools or any measurements.
Right, like I said, I just inspected the shower, and we were able to come to that conclusion.
Now, you previously testified that your handyman replaced the caulking in the shower, correct?
Yes, the handyman took out the bad caulk and replaced it with that higher quality caulking.
And you described this as high quality caulk, correct?
Yes.
Members of the panel, I would like to now turn your attention to Exhibit M, also found on page 35 and 36 of the case file. Are you familiar with these photos?
Well, I saw them earlier today during this arbitration a few times.
Could you tell us when these photos were taken according to this exhibit?
It says November, doesn't it?
Yes,
Yes.
It says November 1st.
Okay.
Now, you had a handyman apply high quality caulk in August of 2019, correct?
Yes, yeah.
So
And
this is a picture showing the state of the shower after you replaced the caulk. Isn't that correct?
yes, yeah, that's what that date indicates.
And wouldn't you agree that this caulk is cracked and crumbling?
Yeah, and again, that's in November. When I saw it in August, it looked good. The issue was fixed.
Thank you. No further questions.
All right. You have anything further, Respondent?
Yes, redirect, Chief Arbiter.
Briefly, sure.
Now, Ms. Garrison, do you need to attend a trade school to faithfully fulfill your duties as a project manager?
No, I've worked for 10 years at Palace Protection and received great training that I use every day in my home repairs.
Did you ever claim to be a structural engineer?
No, I didn't. I do my job and I do it well.
Are there multiple reasons as to why a shower might leak?
Generally, a shower leak is caused by bad caulking or poor maintenance. And here it was clear that recaulking would fix the issue, and it did.
Did the warranty agreement itself require you to step in and perform a caulking job?
No, it didn't. That bronze level warranty didn't cover that, but we were happy to do it as a courtesy to Ms. Jackson.
Do you believe that you properly assessed the leak?
Absolutely, the issue was fixed. I saw that and a worker saw that.
No further questions, Chief Arbiter. We ask that this witness be excused.
All right. Please don't discuss your testimony with any other witnesses who may testify. Does the respondent have anything further?
No, Chief Arbiter. At this time, the respondent rests its case in chief.
All right. Is the respondent ready for their final argument?
Yes, Chief Arbiter.
All right. Is everybody there? Go ahead, sir.
Chief Arbiter and members of the panel, Sammy Jackson is entitled to her own opinion, but not her own facts. And the facts in this case are that the warranty agreement unambiguously delineates what is and what is not covered. While we empathize with the issues that Ms. Jackson experienced in her home, if we look to the contract itself, the evidence shows that there is no breach and no bad faith on the part of Palace Protection. It may be Sammy Jackson's opinion that the shower leak should be covered by the warranty, but Claimant failed in proving that there was a defined structural element failure under the warranty that would trigger coverage. And once again, in regard to our defamation claim, Ms. Jackson may be entitled to post her opinion online, but the assertion that Palace Protection workers are deadbeats and provided no help is simply not the truth and is a misstatement of the facts. Now, first, I'd like to discuss the breach of contract claim. Contracts exist so that both parties are clear on what was agreed to. And Sammy Jackson agreed to the terms laid out in the bronze warranty. To prove a breach of contract, Sammy Jackson must prove by a preponderance of the evidence 4 things: a valid contract, that she performed under the contract, that Palace failed to fulfill its obligations under the contract, and that she suffered damages. Now, the contract at issue is a warranty agreement. Warranties, of course, provide protection should something go wrong, but there are different levels of protection that consumers can opt for. Despite Sammy Jackson's statement that she may not know much about construction, warranties are not exclusively used in real estate purchases. Warranties aren't uncommon when purchasing a number of things like televisions, appliances, a range of products. And Sammy Jackson herself stated that she knew of the different levels of protection, stated that Mr. Chambers explained it to her. And Sammy Jackson willingly picked the bronze level warranty, which does not extend to faulty plumbing or mold and mildew. Now, members of the panel, it is clear that no breach occurred if we look to the 2 things that this case boils down to: plain meaning and common sense. Now, as to plain meaning, the bronze warranty's unambiguous language explicitly only covers defined structural element failures. You heard from Sammy Jackson herself about the plain language contained in the warranty agreement. She understood that things like moisture, mildew, and faulty plumbing were not covered. She understood to reach out to Cortex first. And you heard from Carrie Chambers today as well, the sales representative who sold Ms. Jackson the warranty agreement. Now, Carrie Chambers stated that he made clear the limits of the bronze warranty when selling the package, didn't reassure Ms. Jackson of anything regarding mold, and walked with Ms. Jackson step by step. Now, you also heard from Gail Nico, who was hired by Sammy Jackson to complete an assessment. And I find it remarkable that opposing counsel asks of you to twist Gail Nico's words to fit a shower leak within the warranty agreement's confines when Mr. Nico fails to state anything in his expert report that would lead to any issue constituting a defined structural element failure as it's contained in the warranty agreement. Now, in Gail Nico's expert report that was never provided to Palace Protection, he never once mentioned a joist deflection, a truss deflection, or a crack in the foundation. Gail Nico stated that tools are generally necessary to complete a thorough assessment in looking toward the structural integrity of a home. And for as qualified and educated Gail Nico claims to be, let's examine what work Gail Nico actually completed at Sammy Jackson's home. Gail Nico didn't look at the underlying floor. Gail Nico didn't use any other tools than merely placing a level down on the floor. Gail Nico didn't measure the shower itself. Everything else that Mr. Nico said is mere fluff and putting lipstick on a pig. In regard to his expert report, Mr. Nico stated he merely placed a level down to determine that the floor was uneven, charged $10,000 for it, and recommended $79,000 in repairs based off of the little observation that he had done. And aside from this, Gail Nico also stated himself other causes as to a shower leak, in that the builders from Cortex had simply forgotten to attach certain clips when installing the shower, which led to the unnecessary price paid of $79,000. Not just the shower, but a new toilet, a new vanity. These were not modest repairs by any means. So even if there was a structural defect, the claimant failed to mitigate the cost that they incurred by having such extravagant repairs done. And now for a second, let's talk about common sense. What occurred leading up to this proceeding defied common sense in many instances. Now, it's understood that people entering into a contract exercise at least some reasonable precaution before signing. And if Sammy Jackson wanted Palace to step in to correct issues associated with mold or faulty plumbing, they could have opted for that higher level protection plan. Ms. Jackson didn't consult any other engineers, didn't do any further research before authorizing $79,000 in repairs. and now brings this claim solely in hopes of getting Palace to foot the bill for an unwise expense entered into for something that's outside the bounds of the warranty agreement. Now, as to the second cause of action, bad faith, it was incumbent upon the claimant to prove that Palace knew of the issue and deliberately shirked its responsibility to adhere to its coverage under the contract. Now, there are various causes of why a shower might leak, but we found that caulking remedied the issue. Opposing counsel failed to prove that Palace acted maliciously in refusing help because Palace Protection properly dealt with the situation. Palace had only been informed of a leak in the shower, had never been provided any sort of information as to a problem with the foundation of the home. The expert's assessment, his report, had never been provided to Palace. Every single time that Ms. Jackson called Palace Protection, the only issue discussed was that of a shower leak and nothing relating to the floor. And you heard from Palace's project manager today, Lori Garrison, who stated that when she was informed of a shower leak, she immediately knew how to handle the situation. She relied on her training and experience, figuring out that all that was necessary, all that was needed was new, higher quality caulk. Then Ms. Garrison stopped by a week later to observe that there was no leaking from the shower. And all of this was done, nonetheless, as a courtesy. Palace Protection was never unwilling to assess the issue. And no matter how many times you state a certain set of facts, the simple fact of this case is that Ms. Jackson's issue was not covered under the warranty. Now, lastly, I'd like to discuss the defamation claim. All that we must prove to show defamation under New Dover law is four things: that Sammy Jackson published a statement that was a false statement of fact, understood to be about Palace Protection, and that harmed Palace Protection. Soon after arriving in town, Ms. Jackson took to social media to disparage Palace's long-standing established reputation with the Sunshine City community. Throughout the years, Palace has solidified itself in New Dover as a reputable company, diligently displaying loyalty to its customers and workers. And that is why Ms. Jackson's published falsehoods about Palace shocked the community and hurt Palace's business in the way that it did. Ms. Jackson's assertion that Palace provided no help is a blatant lie, a misstatement of facts, in that Palace sent an agent to caulk her shower when they had no obligation to. And in return, Sammy Jackson called Palace workers deadbeats. You heard today from Carrie Chambers that such statements caused Palace damages of approximately $150,000, where they lost future business due to these untruthful comments. From viewing these posts, afterwards, Palace lost out on a profitable home warranty with some new clients and learned that Quality Construction, a large home builder in the area, decided it would no longer refer clients to Palace for home warranties after these published falsehoods. And the lies that Palace offered no help couldn't be more inapposite to the facts presented to you here today. And they placed Palace's future business ventures at stake, put the very livelihood of Palace's workers at stake. And the crux of this case is that we had a contract, and it was clear, unambiguous language, and we followed it. While we empathize with the shower leak and the water on the floor that Ms. Jackson experienced, she agreed to the contract, and it defies common sense to shift blame to Palace in a grasping attempt of pointing fingers at the company whose responsibilities under the warranty agreement were never triggered. We heard a lot of opinions today as to what is and what is not covered. But the fact is that even Claimant's own expert can't even state with certainty as to how these issues constitute a defined structural element failure under the warranty agreement. And it's for these reasons, in correlation with the contract's plain meaning and common sense, that we request that you, members of the panel, find Palace not liable for the unfounded claims brought against them. And it's for these reasons also we request Sammy Jackson be found liable for defamation and that Palace be awarded on all accounts for all relief that it may be entitled to. Thank you.
Thank you. Claimant, you ready to proceed?
Thank you, Chief Arbitrator. This dispute comes down to both broken promises and bad faith. Think back to Sammy Jackson's testimony about the hard work and time Miss Jackson had put into realizing her dream. And now think about the fear that Miss Jackson had for her well-being and the undeniable mistreatment she received from Palace Protection. Members of the panel, Miss Jackson suffered through this problem for 8 months, turning her dream retirement into an 8-month-long nightmare that you now have the power to make right. Palace Protection is entitled to their own opinion, but not their own facts. Opposing counsel cannot allege that this was only a shower leak, nor that the issue was resolved, when testimony and evidence provided today suggests otherwise. You heard opposing counsel state that words have meaning. This is very true. And when Respondent sent Ms. Jackson an email on November 1st stating, "You are on your own," those words had a meaning and a consequence. The abandonment of Ms. Jackson and resulted in this arbitration. Opposing counsel claims that Ms. Jackson was to simply follow the plain meaning of the contract. And Sammy Jackson followed the contractual policies precisely, and opposing counsel was not able to prove otherwise today. However, Palace Protection still failed to live up to their promises, leaving Ms. Jackson on her own. So she sought help elsewhere in order to save her dream. As you have heard today, the repairs done to Ms. Jackson's home were in fact very necessary repairs of a very serious structural defect that took 8 months to finally diagnose properly. Ms. Jackson wanted help, deserved help, but Palace Protection did not provide any help. Today we have shown 3 reasons why the panel should rule in favor of Sammy Jackson on all claims. First, Ms. Jackson followed the plain terms of the contract, thereby effectively triggering coverage under the home warranty by Palace Protection. Second, Palace Protection breached their contract. In doing so, they engaged in bad faith by purposely avoiding Ms. Jackson's claim that her problem was due to a structural defect, by ignoring her repeated phone calls and emails over the course of 7 months. And third, opposing counsel had the burden of proof for their defamation claim, but no evidence or testimony was sufficiently provided today that supports that claim. As for our first point, you have heard from Sammy Jackson that she did all she could do to warrant help from Palace Protection. Respondent has emphasized that Ms. Jackson signed the limited warranty bronze package. Although this is true, limited warranty does not mean no warranty. In fact, the situation that Sammy Jackson was in was one that should be fully encompassed in the bronze package that she signed. Respondent has argued that Ms. Jackson was required to follow the plain terms of the contract. Ms. Jackson's testimony shows that she in fact understood the plain terms of the contract. And as Respondent conceded, there is no language in the contract that conflicts with Ms. Jackson's understanding. Ms. Jackson knew that she had to first seek redress with her original builder before contacting Palace Protection. Respondent alleges that Ms. Jackson had to exhaust all options with her original builder before she may contact Palace Protection for help. But as Respondent conceded today, he continued to use this phrasing, even though it's never once mentioned in the contract. Rather, the contract states that Ms. Jackson had to first seek redress with her original builder before she may contact Palace Protection for help. This provision does not state how many times Ms. Jackson had to seek redress, nor does it state that she must provide proof of her contact with her builder, as Respondent alleges. Nevertheless, as you have heard from Ms. Jackson, she contacted her original builder, Cortex, every day for months to no avail. Cortex attempted to help her by recaulking her shower in March. However, the leaking continued. Cortex then attempted to help once more in April when a project manager, Jamie Sanchez, opined that Ms. Jackson's shower enclosure needed to be replaced and further noticed that something was off in Ms. Jackson's bathroom. But before Cortex could sufficiently repair the problem, they went bankrupt. Because Ms. Jackson knew that as per her contract, she had to first seek redress with her builder before Palace Protection could step in, she finally contacted Palace Protection once she learned that Cortex was bankrupt for their full assistance, expecting them to step in and fix the problem. However, as we know, that did not happen. When Palace Protection finally stepped in, they sent over a project manager to assess the problem. Today, Ms. Garrison stated that the caulking worked. In fact, you heard Ms. Garrison testify today that this was a long-term solution to Ms. Jackson's problem. However, this was actually a 7-day solution. And after those 7 days, Palace Protection wiped their hands clean of their client, Ms. Jackson. Ms. Jackson testified today that she completely understood the contract and only continued to call because the problem had gotten worse, and she believed it was caused by a defect in her bathroom, and even specifically requested an engineer to assess her home. However, one was never sent. As Mr. Chambers said today, everything was good, the caulk had worked. Yet Ms. Jackson continued to call. And as you heard today, Mr. Chambers conceded that he fully stopped answering Ms. Jackson's phone calls. And he also conceded that he therefore had no knowledge of what she was calling about. What's more, after ignoring her phone calls for 3 months, Palace Protection officially denied her assistance when Mr. Chambers sent an email to Ms. Jackson stating that she was on her own, with no knowledge of what claim they were even denying. Nonetheless, Ms. Jackson's testimony shows that she reasonably believed this email and her multitude of ignored phone calls meant that Palace Protection was no longer going to help her fix the problem. Understanding that the contract required notice of a defined structural element failure to warrant coverage, Ms. Jackson hired Gail Nico to assess her home, who was confident that there was in fact a structural element failure that required immediate repairs. As Respondent concedes today, the contract never states when a warranty holder is required to provide this written notice, nor does it provide exactly how Palace Protection will assist with the defect. The contract merely states that Palace Protection must receive written notice of the defined structural element failure within 30 days after the expiration date of the coverage. Well, 8 months into a 5-year contract where Palace Protection failed to fix the problem properly, refused to send an engineer to assess for structural defects, and even refused to simply answer Ms. Jackson's numerous phone calls, Ms. Jackson was, as she states, abandoned by the respondent. Ms. Jackson was tired of waiting for help from a company who purposely avoided her calls for help, and therefore she made the proactive decision to hire Mr. Nico, who came to her home the same day she called, and to subsequently hire Zono Construction to do the desperately required repairs on her home immediately. Respondent alleges that they are the only party who can do repairs, but nowhere in the contract does it exclude reimbursement for repairs done by an outside contractor, nor does it state that this is the exclusive job of Palace Protection. Respondent has argued that Ms. Jackson did not follow the contractual procedure, but they have failed to point to a time in their correspondence with Ms. Jackson where this claim is true. And Ms. Jackson, now in full reliance on the contract signed with Palace Protection, requires them to cover those costs to prevent her financial loss and potential bankruptcy, as they promised. Is this situation not what the bronze package was exactly designed to cover? The repair of a structural defect in the home after it has been assessed as such? As you can see, this case is more than contractual. Palace Protection clearly took advantage of Ms. Jackson and acted in bad faith when Respondent purposely avoided Ms. Jackson's calls and emails for months, refused to send over a professional to assess the situation, and then finally informed their paying customer, Ms. Jackson, that she was on her own. And finally, to our third point, opposing counsel had the burden of proof for their defamation claim. And opposing counsel said that they would show the direct harm Palace Protection suffered due to Ms. Jackson's posts. But they failed to provide sufficient evidence or testimony to support this claim. Respondent's claim cannot be corroborated. They have not definitively shown that Ms. Jackson's posts were the reason that a client decided not to purchase a home warranty. And therefore, they failed to prove that this was the root cause of their loss in business. As you heard today, respondents were unable to produce any documents corroborating their alleged financial loss of $150,000. Similarly, they failed to prove that the statements made by Ms. Jackson were false. Rather, these posts were mere opinions outlining her own experiences with Palace. Could you imagine if every time a customer left a bad review of a restaurant, they could face a lawsuit worth of $150,000? Arbitrators, these posts are merely opinions left by Ms. Jackson, and therefore these posts do not amount to defamation, as Respondent has argued. As such, we ask that you find respondents liable to Ms. Jackson for $89,000, which represents the cost to complete the covered repairs under the home warranty and for the engineer assessment. We also ask that pursuant to New Dover Review Insurance Statute 79, respondent be liable for any and all attorney fees due to its bad faith in refusing to cover Sammy Jackson's claims, as well as treble damages, which will equal 3 times the contract damages, totaling $267,000, and any other remedy that this panel deems appropriate. Members of the panel, this case is about the broken promises and the bad faith of a company that affirmatively ignored their client for months. You've heard the facts and the testimony of the case. You can understand the frustration, the fear, and the abandonment that Ms. Jackson felt during this 8-month nightmare. Ms. Jackson did everything she was required to do under her contract and deserves to be compensated for the lack of respect and attention that she received from a company that took her money without a second thought. Ms. Jackson wishes nothing more than to leave this nightmare behind and to leave her anxiety and her fear behind with it. And you have the power today to grant Ms. Jackson that relief. Thank you for your time.
I'm going to start. I'm Joan Churchill, and I'm a retired immigration judge. And I retired a number of years ago, back before anyone had ever heard of immigration judges, but now I think our function is well known. I wanted to compliment all of you. You all did just terrific. And just as an aside, I just want to say I thought the witnesses really did well. Very terrific witnesses. Let's see if I know everybody. Margaret, I was very impressed with you. You were very specific and direct and seemed to cover all the bases. Who's next? Drew, you were on the respondents team, and you were very persistent and really got into things. Sean, is that it? Stan Lewis, yes. I was very impressed, particularly with your speaking style. You had a way of coming across very clearly, and you were sort of a joy to listen to. So that's important for people who are in litigation, right? Let's see. Nico, is that your real name? Okay, I get confused, but you were a witness, right? So you're not one of the lawyers, and Carrie and Sammy. So who haven't I mentioned? Joshua, yes, you came across very well too. And let me see, who was it? I think you were the one who was reading. Did you do an opening, Joshua?
No, I'm one of the judges.
I did.
Joshua Zelen.
Yes.
Joshua, I think you were the first one to present, right? And so I noticed you were reading, and somehow it came across a little flatter so I would just suggest you think about how you present things. And the last person, have I covered everyone? Drew and Joshua? I think I've covered all 4 of the advocates, right? So I'm going to wish you all very well. I have to leave because I have to actually drive several hours now, and it's getting late. So I'm going to wish everybody goodbye and compliment you for, I know an awful lot of work went into the preparation, and I think it's all worked out very well doing it on Zoom. And I want to thank my fellow judges. We didn't get to visit any, but anyway, it's been a great experience being together with you two. Okay.
Drive safely.
Thank you. Thank you, Judge.
Thank you.
And I won't know who won unless Erica sends an email later.
She will.
Best of luck. Okay, bye now.
Drive safely.
Thank you. Thank you.
Helen, you want to go next?
Who?
Helen?
Oh, sure. Hi, everyone. I'm Helen Paxton Arnold. I am also retired. I'm a retired public defender in Cook County, which is mainly Chicago, but also a lot of suburban areas. First, let me give kudos to all of you. This new age that we find ourselves functioning in, I know cannot be easy, and I know how much work it took for all of you to get to this point. So that's wonderful. I think all of you did a great job. I have a few specifics for each of you. Josh, I loved your opening, and I thought that you summarized your case very well. And I also thought that you used the exhibits really well in the opening. It was a seamless transition between the exhibits and what you were stating. Margaret, I thought your direct of Sammy was excellent. And that clearly you prepared your witness very well. And I thought also that you made good use of Palace's own documents to make your case through your witness. Is it Sean or Stan for the respondent?
It's Sean.
Sean, hi Sean.
Hi.
I also thought your opening was excellent. Both you and Josh in your openings not only stated your cases very clearly, but in an arbitration, especially, I think, as opposed to a trial, it's really critical to get out at the very beginning exactly, what you're trying to have the arbiters do for you. And I think both of you did that very well for your opposing sides. The direct of Chambers was good, and Chambers was a really good witness because he seemed like an oily salesman to me. And I thought you did clearly well prepared. I did have, I thought that your objection to accepting Nico as an expert witness was particularly well stated, Sean. If this had been real, I would have overruled it, but I thought you stated it very well. And I forgot your partner's name.
Drew.
Drew, yes. Drew, I thought you did a really good job in your summation, and you were very aggressive in your cross, which is, which had to be in a cross examination, especially in a situation like this one, to me, where the facts are really not in your favor. I thought that you actually were very argumentative with Nico, but that's your job. You're trying to make sure that the panel, decides for your client. Excuse me. Let's see. The one thing, Drew, that I had when you crossed the claimant is that you didn't make clear that the mode, which she said she had an allergy to, was explained in her deposition. And so you you made a statement about that, but it wasn't testified to today. And just, in real life, make sure that you're connecting all the dots, because if that had been a real arbitration, the panel would have been scrambling to figure out when this information had been given, since she didn't say it today. The summation in the Palace case was also very good. You know, 1, 2, 3 went to all the points that I keep saying plaintiff, that the claimant needed to prove. Again, in my opinion, the facts weren't on your side, but you still did a very good job of making your case. Kudos again to all of you, and the best of luck. I thought all of you did a great job, and it was my pleasure to listen to you today.
Okay. Judge Ehrlich, you want to go next?
Sure. Hello, everybody. My name is Chuck Ehrlich. I used to be a big firm litigator, and then I was in-house for quite a number of years. And I now serve as an arbitrator for AAA and some other organizations. I'd echo everybody, really great work. I think I ended up like 1 or 2 points difference between the two teams. So there's really no losers here, in my opinion. Some comments. First, my sense is arbitration's a little different than trial, and one needs to. Drew was very good at going after the witness, but one thing about arbitration, in my experience, is when you're in a room and not on this crazy Zoom thing, is you don't want to make people feel uncomfortable with the situation. And so to some extent, I think you want to moderate a little bit what you might be doing if you were in a trial, as opposed to being in an arbitration. Because when you're sitting in the seat of the arbitrator, you feel a little bit uncomfortable when a witness is truly getting whacked around, unless they really deserve it, which then you like it. But I thought the claimants group did a great job in focusing on the contract. You could easily have come in here with, oh, the woe is me, poor old Sammy got ill-treated by these people. And I think you guys should all go to acting school, actually. I mean, Sammy was really great at just being a person. But again, you also focused, and this is, I'm sure, your preparation, you focused on the contract, because when I'm sitting there as an arbitrator, that's my first question when I hear the claimant. Tell me why you're supposed to win. Before you tell me that you're a wonderful person and the other side is a bunch of really bad people, what's the legal basis for you to win? And that's one slight criticism of the opening for the claimant. You tried to cover an awful lot of stuff. And I was a little bit looking more for the 1, 2, 3. This is why we win. And now let's talk about everything else. Particularly bear in mind that you kind of assumed a little bit that everybody knew the facts. You won't always be in front of a panel or a judge or a jury that's paid all that much attention. And to some extent, you're starting from scratch, even though everybody should know what's going on. So it's kind of a better idea to start out and here's where we're going, here's what happened, and here's why we win, 1, 2, 3. Now let me deal with these other issues. Let's see. On the other hand, in the opening for Respondent, there was a really good focus on the contract. And another thing that you did very well was modulation, differences in tone. You asked that question. They had no, or you said they had no obligation, but they did. And that was good. That sort of giving it a little bit of drama, it was very good. Because, most of the stuff you're going to do when you become a lawyer is boring stuff. And so you need to come up with a way to keep the attention of whatever audience you have there. I don't want to take too much time here. Let me see here. On the direct examination of Sammy, a lot of leading questions, but you get away with it. a little bit more of an emphasis, I think, on acting as if you're really interested in hearing the answers. There was a little bit of like, I got my list of questions and I know the answers and I'm gonna go through my list of questions. But if you want me to be interested in the answers, you want to look interested in the answers yourself. Let's see, so hard to read my handwriting. Yeah, again, focus on the contract was great. Claimant's witness told a really nice, clear story. Let's see, again, focus on the contract. Don't want to repeat myself here. Oh, both sides don't crap on opposing counsel. That, again, that just makes whomever is hearing the case uncomfortable. Just as an aside, one of the things I was told lawyers when I was a client was, don't put any adjectives in your briefs. You know, no stuff about how whatever the other side did is the worst thing since Sodom and Gomorrah and the greatest atrocity since, I don't know, the Khmer Rouge or something like that, because it usually isn't. And one's tempted to do that. Certainly I was tempted to do that as an early in my career. And then the last comment, which is a little bit of a, try to give a roadmap where you're going. Particularly, I put this comment here, I think in the summation. Yeah, the summation for the respondent. It's helpful to say to the panel, I'm going to cover 4 issues now, or 4 questions, or I'm going to answer 4 questions. Those questions are, A, why the contract, why we should win on the contract. B, why we win on defamation. C, why we win on, the more roadmaps, the more signs you can give, the better off you are. So everybody's great. I don't know what everybody plans to do when they're done, maybe become corporate lawyers or whatever, which is really boring, so don't do that. But yeah, it's super. I know everybody worked really, really hard. So A+ on that. And I love the accent of the person who came in to fix things. So, okay, anyway, thanks.
Okay. Judge Richter, you ready to go?
Yes, sure. So I really, up until this July, I really was Judge Richter. So for the past 30 years, I've been a New York State court judge, including 11 on the appellate court. And then, as my background says, a few months ago, I joined the law firm of Arnold and Porter, where I do a mix of litigation and also I'm doing some mediation and arbitration. So I've sort of seen this a little bit now from both sides. So I have a few general comments and I'll try to get into specifics. So and again, I will tell you, I've been a judge now a very long time. I felt like there was a disproportionate balance on both sides of the first witness. And this case, in my opinion, is all about the contract and about the experts. And they were afterthoughts on both sides. And that there was a lot of sort of pulling at the heartstrings. I should, all about Sammy and her retirement and what she knew or didn't know. And I was sort of sitting and listening going, this is a contract case. And so just something, there may be multiple arbitrators, different people are going to have different takes, but that was mine. And I didn't hear that in the opening. I wanted to hear more in the opening about the contract, about the burden of proof. I heard, Margaret, I thought it was really great that you had the burden of proof in your summation. But it would have been good to hear about that from the get-go, the lack of proof about documentation of the damages on the defamation claim. Drew, that was in your summation. So I think also thinking about deficiencies that you anticipate, I think that can be raised in the opening. Just, they're not going to be able to prove this, and this. And again, I think that if you've done a lot of work on jury trials in law school, you really have to think about the difference between pitching to judges or arbitrators and pitching to juries. And I have a note sort of on the claimant, all this, and the respondent too, all this discussion about what Sammy understood. And I'm sort of thinking, as a former judge, there's a contract case, it says what it says. It does, there's no claim she doesn't speak English. So I just want to sort of throw that out, think about your audience. And both sides fell into, in my mind, turn this into some emotional case. And it's really all about money. That's all this case is about. And I just, maybe a general other comment, again, it's a style thing. I didn't know why both sides spent a lot of time asking people to read from documents that were up on the screen. I could, like asking a witness to read a contract, it's right there. And I think if you're third year students, I do some training now on Zoom meetings and mediations. This is the future. Courts are not opening up anytime soon. So you want to think about sort of how does screen sharing technology change the dynamic? Because maybe when everyone was in person, the trier of fact couldn't see the document, but I just throw that out because you were sort of asking the witness to read along. And I didn't know quite where we were going. I thought overall, everybody's voice tones and style were excellent, excellent eye contact across the board. A small tip, Margaret, you tend to nod your head in agreement when the witness was giving you the answer that you wanted. And these are things you don't notice unless you, so that I thought that you want to try to work on that. A couple of other of you did the opposite, like you sort of had that little scowl when you didn't like what the witness did. Again, particularly in Zoom land, as I call it, you really want a little more of a poker style. Let the witness's facial expressions do the talking. I thought both sides just did a terrific job on summation. You clearly knew your case, and I would just say across the board, I was totally impressed at your mastery of the record. I really thought that was particularly good. So congrats to all of you. You're going to be fabulous lawyers. And that's my comments. So I've let the chief arbitrator take over.
My name is Haskell Pitluck. I'm a retired circuit court judge in the state of Illinois, McHenry County, which is about 55 miles northwest of Chicago. Now I happen to be in Florida, and I happen to call these dooms, not Zooms. But I have some information that I'm going to basically just give for all from a few years of experience. But everybody was mostly very polite to witnesses. You got on them a little bit, a couple of you. You all knew the case. And I know it's hard, especially now, but try to loosen up and relax a little bit when you do it. Don't be everything canned, be flexible, and be ready to do it. One of the things that I really loved, I think it was it Sean? I wrote it down. Don't say to a judge, you know, because what did I say to you? I think I said, no, I don't know. That's why I'm asking you. You got to assume that judges have to know that. And when a judge asks you a question, don't say, I'm going to cover that later. They want to know about it right then. One of the other things that you did, you stipulated to a bill, and it was not a paid bill. Well, I'm sure you've all had contracts by now. You've got to show that a bill was paid. And if you want to stipulate it, that's fine. But that was a pretty hard bill. Maybe we should all change jobs and become structural engineers because he made $10,000 on what he did on that. That's like saying, you know, I could hit it with a hammer, but I knew where to hit it. Don't make objections just because you make them. Don't make them if you don't think they're going to do you any good. Make them if they're really good objections. You probably don't even know what hypothetical questions are anymore, but they used to do those all the time. I always objected at some point in a hypothetical question because the person that was preparing it would always leave one or two things in the change that sometimes the witness wouldn't listen to. And by making an objection, you'd throw them off their track and they had to think about it and start over. I had never ever thought that I was going to ever win the objection, but it was a strategic time to make it. Don't read something unless they ask you to do so if you're going to call a witness. And if you're a witness, you should not go and volunteer all the stuff that you do because you just answer the question. And a couple of times when you let the witness answer the question, I can't remember quite frankly if it was Sheen or Sean, I'm sorry. Was it Sheen or Sean?
Sean.
Sean? Just a second. When you get a bill that's very large like that, and you want to find out why. And the other thing that wasn't in this opinion, in the problem, how much did that house cost in the first place? If that house cost $100,000, then $79,000 to fix a shower or a floor is really something you can all argue about at a later time. Ask him what he did for all that money. Hearsay is a very interesting thing, and it's all kinds of questions about hearsay. And I had a trial one time when the lawyer asked the witness's name and the other lawyer objected on a hearsay. He said there's no way that person would know their name when they were born. Somebody had to tell them what it was. What I gathered from that was I knew it was going to be a long afternoon. If you go to trial, and you probably haven't done it a lot now, obviously even in court, go back and read a transcript because you'll find out that we don't talk the way that we think we talk. For instance, one of the examples that I picked out here was when they cross-examined the young lady who said, yes, I am not an expert, or I'm not an engineer. If you read that and you don't take it in context, it looks in the transcript like that you answered it wrong. So it's really helpful. It was always helpful for me to read transcripts. And I figured you can read about 100 pages of transcript an hour without any problem whatsoever. So it's very good, good training. I also like lipstick on a pig, but that's depending where you're trying a case, it may have more effect than another case. So be careful with it. Yeah, that's when she said, is that correct? And she said, no, I'm not a licensed engineer. Do you remember that? If you get the transcript, you'll read that and you'll wonder what's going on, and maybe that's something I can talk about. I think you all did a great job. I apologize to everyone for my screw up on my computer. But by the time you get to this range, there's not much difference in points because you all do such a good job. And I would bet that nobody had anything lower than a 7, but I don't know. And I didn't have one of those. So congratulations and good luck. And enjoy, unless you want to become a structural engineer. Thank you.
Thank you all.
Say, Kristen, would it be wrong for the students to tell us where they are now, what schools they're at?
We'll announce that in just a second.
Oh, okay.
Yeah, and my co-committee members should feel free to turn their video on now as well if they would like. There's Maureen, thank you. there's Erica and Connie. So thank you all. We all watched your final round, which was really convenient and easy on Zoom. The more that I do on Zoom, the more that I like Zoom. And one of the things I did want to note, thank you all to our judges so much for your critique. And one of the things that I noticed as I was listening to all of you that I think the students should think about is that different people enjoy and respond to different strategies. So you've heard a lot of different pieces from your critique, and I think it goes to this fundamental idea that that judges, juries, and arbitrators are looking for different things, and what one arbitrator finds to be very persuasive, another does not. And so, and that's why we do these competitions to not only teach you skills on how to be better advocates, but also in order to give you some exposure to what to expect in the future. So thank you all. Thank you very much for those critiques. They were very valuable. I agreed with all of them, even though they were all very different. And so, so I thought that was very nice, and I am glad that you did that. And so we have tabulated your scores. Erica will be sending them out momentarily, but we can say already, we can announce that the winner of this year's 2020-21 arbitration competition is team number 3 from Fordham University. So congratulations to team number 3 from Fordham. And just so everybody else knows, team number 5, our runners up, you performed very valiantly from Texas Tech. And so this final round was Fordham versus Texas Tech. And so congratulations to both of you. I would like to very briefly thank Sarah and Erica and the ABA, Maureen, Connie. Yesterday you also saw Carly and I. The 4 of us are not ABA staff. We are law professors from across the country, and we wanted to give a big thank you to Sarah Stretch and Erica Zapita for their work in putting this on. So thank you to them.